Yeah, we're good.
Planning also.
Good evening and welcome to the Bridgewater Township Planning Board regular meeting for Tuesday, May 21st, 2024. Adequate notice of this meeting has been given in accordance with the Open Public Meetings Act, NJSA 10:4-6. On February 7th, 2024, proper notice was sent to the Courier News and the Star Ledger and filed with the clerk at the Township of Bridgewater and posted on the municipal bulletin board in the municipal building. Please be aware of the Planning Board policy for public hearings. No new applications will be heard after 9:30 p.m. and no new testimony will be taken after 10 o'clock p.m. Hearing assistance is available upon request. Accommodation will be made for individuals with a disability pursuant to the Americans with Disabilities Act, or ADA, provided the individual with the disability provides 48 hours advance notice to the Planning Department Secretary before the public meeting. However, if the individual should require special equipment or services such as a CART transcriber, 7 days advance notice, excluding weekends and holidays, may be necessary. Would everyone please rise to salute the flag?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Probst, have a roll call, please. Here.
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 Thank you, Ms. Probst.
Yes.
Here.
Thank you, Ms. Probst. At this time, any members of the public that wish to address the board on any land use matter other than any other application that's going to be heard this evening, please feel free to come forward at this time. Okay, seeing none, moving along. We do not have any minutes up for adoption or approval this evening. We do have one resolution this evening, and that is for the Hidden River Farms, or the Hall residence, commonly known as 639 Meadow Road. Are there any questions or comments or changes to the record? Hearing none, could I have a motion to adopt the resolution memorialized on May 21st, 2024?
So moved.
That's Mr. Pappas. Could I have a second, please? That's Mr. Chowdhury. A roll call, please. Yes.
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 Yes, please.
Yes.
Thank you, Ms. Probst. Moving on to our application portion of the evening. We do have Hula House returning, more commonly known as 147 Chestnut Street. Good to see you this evening, Mr. Silbert.
Good evening, Mr. Chairman. Good evening, board members, board professionals, members of the public. My name is Michael Silbert, and I'm an attorney from the law firm DeFrancesco Bateman, located in Warren Township, New Jersey. I have the privilege of representing the applicant this evening, Ms. Hula Haas. As I'm sure the board recalls, we originally presented the application on April 16th, 2024, and then we returned to the board on May 7th, 2024. I'm sure at this point the board is all too familiar with the application, so I'm not going to waste any time outlining the application again or what brought us before this board. I think, however, it would be prudent to remind the board where we left off before we concluded the last meeting on May 7th. So at the last hearing and at the request of certain board members, Ms. Huss agreed to increase the minimum side yard setback on the northern side of Lot 12, adjacent to Lot 15, and that increase was to 15 feet. The side yard setback on the southern side of Lot 12, as a result of that, the applicant agreed to ensure that it would be no less than 9 feet. That resulted in a change to the minimum combined side yard setback for Lot 12, where the combined yard setback would be no less than 24 feet. As relates to screening or buffering, that was a concern of one of the objectors at the last hearing, as well as the board. And the applicant agreed to provide screening or buffering in the side yard setback to the northern side of Lot 12, again, adjacent to Lot 11. This can include fencing, vegetation, landscaping, or a combination of them. Obviously, the goal was very clear. It was to provide screening and buffering to the neighbor on Lot 12. And the only issue was the exact location of the screening. And that was a result of the easement drainage area located on the lot. If we can't locate the document, which we still have been unable to locate the instrument, my suggestion to the board would be that they allow us to install a fence within the easement area, provided that the applicant stipulates to not constructing a fence that anyway would harm or damage existing drainage infrastructure. And I'll remind the board that there is a fence within the easement area on the neighboring lot. The width dimensions of the proposed home on Lot 12, that again was a major concern. We reduced that from 28 feet to 26 feet. So Mr. Stiers prepared a supplemental plan, which he'll present to the board. I think it has to be, Mr. Peck, it would be A4. We can mark it when it gets there. But assuming approval is granted, the maximum width permitted would be 26 feet for any dwelling on Lot 12. And the width would be, as shown on the supplemental plan, would be 41 feet. The depth would be 41 feet. The applicant agrees to comply with the following. Just to be clear, again, that the lot width of a home on Lot 12 shall not exceed 26 feet, so as to comply with the single minimum yard setback with the neighboring Lot 11. FAR on Lot 12 shall not exceed 25%, which is the maximum FAR permitted in the zone. Lot coverage on Lot 12 and really on Lot 13 as well will not exceed 35%, which again is the max permitted lot coverage permitted in the zone. And again, the applicant reaffirms its agreement to comply with the building height requirements, that the proposed dwelling on Lot 12 will not exceed 35 feet, which is the maximum height permitted in the zone. If it's okay, Mr. Chairman, I'd like to recall Mr. Stiers to present this supplemental exhibit that I described. Yeah, okay. And one last thing, just because Ms. Sarmad made an excellent suggestion about Oprah requesting the ordinances. So I just wanted to outline what I found, if I may. So I did Oprah request the ordinances, and based upon my review, it appears that the R10 zone was established in 1977 when the township's current code was enacted. I point that out because there were amendments that I looked into that took place in 1991, as well as in the early 2000s. None of those amendments had anything to do with upzoning, or I use that term upzoning, meaning that there was never any indication that there was a legislative intent to increase the lot size dimensions in the R10 zone, dating back to at least 1977. I didn't submit a request for an ordinances in place prior to the current code. I would imagine that there were ordinances in place, but again, the Oprah response indicates that this was zoned to permit lots 10,000 with a lot area of 10,000 square feet dating back to 1977. So again, there was never an attempt since then to change that. And that's what I have here with the Oprah request, but I'll turn it to Mr. Stiers, who remains under oath, and I presume your license is in good standing?
Yes.
Excellent.
Thank you, Ms. Silbert.
Yeah, I guess I'll just go through what Mike presented in a list form, and I'll show it graphically. I'm sorry, yes. It's the grading and soil erosion plan, colorized. So the first item, I believe, was that we were to maintain the minimum side yard setback on the north side, so that is 15 feet. The next item would be that the house was going to go from 28 feet to 26, so we've adjusted that, which leaves us with a remainder on the side yard setback of 9 feet on the side yard, southerly side yard. And that would give us a total of 24 feet combined in side yards. Again, Mike said 26 foot wide, 41 feet deep. That's what's shown on the plan here.
Is that 41 or 40?
41. I mean, in any case, it would comply with the maximum FAR and the maximum impervious improved coverage. The other thing, as Bill mentioned, is to remove a portion of the driveway on lot 12. So we've shown that as well. So it gets cut off at the back of the house. So that puts this lot at approximately, I think it was 32.5%. So now both lots comply with the impervious coverage, which was the first driving factor. And then the last meeting was more the setbacks and the configuration. And I think the other thing was that one of the board members brought up a concern about the trees that are currently planted through the middle of the property. And what I've shown is just a number of trees along the rear property line. So that's, I think the intent is to, if at all possible, transplant them and get them along that rear property line. And I think the last item was regarding the fencing. What I've done to this point is shown it along the southerly side of the 10-foot drainage easement. And I'm sorry, a 6-foot privacy fence. So that would go from the front of the house back until it ties into the fence that's currently in the backyard. So I think that covers the list that you just presented.
Yeah, and then one of the neighbors had concerns about the tree on lot 11. That we spoke
Right.
about that a little bit. Can you just show the board where that is? And
Yeah, we've added that tree. I think one of the neighbors came out. One thing important to notice is this tree's probably about 10 feet from their house. And it still survived despite getting that house constructed. And we're 15, maybe 25 feet from that house. So if they can build their house there and it survives, I think we should be okay on ours.
we're 15 feet from the setback.
Well, right, 15 plus another 10, so
Okay.
25, I'm sorry.
Okay. And what was the date of this, just so I can mark it? Last revision?
We put it 5/21.
Okay, thank you. And of course, the garage is gone, but I'll just highlight that the garage on lot 13 has been removed.
Right, the garage is gone, the shed would be relocated, and as I said, the portion of the driveway in front of the garage to the back of the house is also proposed to be removed.
So again, just as a reminder, these are improving existing lot coverage conditions.
Correct.
Thank you.
Thank you very much, Mr. Stiers.
No
I'd
problem.
like to open up to the board for any questions regarding this new testimony. Mr. Chapman?
You mentioned that, fence will be to protect the drainage, fence will be on the other side of the drain pipe, right?
The drainage pipe is in this approximate
Right.
location here. The easement's right on this side.
Yeah.
So we're following the easement, so we wouldn't even be close to the pipe. We'd be 10 feet from the pipe.
Oh, so the fence obviously will not be in the neighbor's property? It will
Oh, no,
be-
no. The neighbor's property is right here. We're 10 feet over. But Mike even suggested that possibly, if we're writing the easement and what's permitted, possibly moving that fence into the easement if the board should let us. So I took the conservative approach and kept it out of it, but, if the board were to choose to allow us a little bit more room, potentially we could do that too.
Mr. Stiers, there is a fence in the easement area on the adjacent property. Is that accurate?
It essentially follows the property line, yeah.
So it's right in the easement area?
Right, dead center, yes.
Okay.
Probably right over the pipe, yes.
Mr. Chairman, a few follow-ups, if I may.
Please, Councilman.
So just want to, I know a lot of numbers were floating around. I think most of them are moving in the right direction, so that's good. But I just want to make sure that everybody on the dais and in the audience, we know exactly what we're talking about. So it's still a 50-foot wide lot. That hasn't changed. The side neighboring lot 11 is going to be 15 feet,
Right.
and then approximately a 26-foot house,
Correct.
and then approximately a 9-foot yard,
Correct.
and that's how we add up to the 50, going 41 deep.
Correct.
Okay, all right. My main area of concern, and it's been the case throughout this hearing, is the lot coverage and concerns about, drainage and, giving water somewhere to go, preferably not into anybody's basement. So where do we stand right now with this rendering on lot coverage for both lot 13 and lot 12? What are the percentages?
As shown, they're both approximately 32 to 33%.
Okay, all right. I'm in a nice mood, so I heard that as 32. Now, the current, as it exists today, is roughly 57. I'm sorry, so it's 32 and 32, so the average is obviously going to be 32. The current is 57 on one of the lots, and the original proposal that we talked about was, I'm sorry, without the improvement, but with the subdivision, lot 12 would be 29, right? So we were talking about 57 and 29 as the two numbers, correct?
I believe so, yes.
Okay. Now, since the lots would be relatively equal size, the total disturbance between the two would be some number that's about an average of 57 and 29, right?
I'm sorry, the existing 12 is 13.5. Existing 13 is 57.3.
Okay. So
Our original proposal were the numbers that you're referring to. Kevin.
okay, so 57 and 13 is 70 divided by 2 is 35.
It ends up being slightly over what's permitted, 35.
Okay.
It's about 35.5.
Okay, so each lot currently, if you evenly divided them up, is about 35% coverage. You made up as 57 and 13. What you're proposing is basically a uniform 32, a relatively uniform 32.
Yes.
Okay, so here are a couple of questions, and I'm hoping that our planner and/or engineer can also weigh in on this. If I'm particularly concerned about drainage in the whole neighborhood, not just these properties, not necessarily just the immediately adjacent properties, is it better, worse, or the same to have essentially a more even situation than a case where part of a lot has a whole lot of building on it and part of it doesn't have much? Or does it make a difference? Does it make a tangible difference? Is it maybe just at the margins?
May I? So it's important to take a look at the percentages, but I think it's more important to take a look at the square footage that is allocated to each property. And if I'm understanding Craig, existing lot 12 and existing lot 13, I think you have just over 4,600 square feet total coverage existing today. With the latest revisions, your total square footage should be less than that 4,600.
I can probably say way less.
So you're going to be reducing the overall coverage
Yes.
on both lots compared to what
Overall.
exists today.
Overall, yes.
But I guess, Bill, really what my question is,
Right. That's what I'm.
is there a benefit to some of a more even landscape
Right.
versus there's not that much going on one lot and there's a whole lot going on the one right next to it?
So I think when you take a look at the drainage area and where the runoff from the coverage is going, these are two small lots. The drainage is all flowing to the same location. So whether you have a 5,000 square foot lot that has a lot of coverage and not so much directly next door. If you develop both properties with lower amounts of coverage, still going to the same spot, in my view, it's a benefit, if that makes sense. So you're looking at a very small area, I think, a little over 10,000, 12,000 square foot total. I think it's an improved condition from a drainage perspective with the way that it's being designed right now.
So given the choice between a whole lot here and not much here, sorry to use my hands,
Yeah.
or more even across, you're saying the water will have a somewhat slightly easier journey if it's more even.
You know, one of the goals of the enhanced stormwater management rules is to break up impervious coverage areas. And I think in that vein, this plan achieves that. So if we can introduce more green space, if we can reduce some coverage, that's a benefit.
Okay. And then the final question, the trees being relocated, which I think is outstanding. If it's the existing ones, terrific. If it's replacements, then that's certainly acceptable. You know, my sense, and I guess I just want it on the record and confirmed, the reason why trees are so valuable is not just they're pretty to look at, but they're absorbing substantial amounts of water.
Correct.
So I guess I just wanted to make sure that that's on the record. It's not just, you know, hey, we want to make sure that it's pretty, although they are serving an important function.
I agree.
Okay. And in this case, we're talking about a one-for-one situation, correct?
I would say it's as many as we can healthily put in.
Okay.
You know, you don't want to jam them all together, but I mean, just based on, because I think they're staggered front to back as well. So if we can get them in there along that line, yes. I mean, we can, you know, if they don't reach the one end to the other, we can supplement as well.
And I know we did have concern from the back neighbor. I guess in this case, once this tree line is in, and certainly if it needs to grow a couple of seasons, there would be substantial benefit, obviously, on that side in terms of a natural buffer and a place for some amount of the water to be absorbed.
Correct.
Okay, thank you.
Should those transplants not survive, let's say, a year or two after they're transplanted, would there be some type of maintenance plan that could be required?
I know that in the past, Scarlett has required a 2-year guarantee, so I would say we'd do the same thing.
Any other questions?
And you'll do the plannings, working with the board professionals to their reasonable satisfaction?
Yes.
Thank you, Mr. Peck. Any other questions from the board?
No.
Mr. Silbert, do you have any further testimony, any further witnesses?
I don't have any further witnesses. I just want to confer with the applicant. She had prepared a statement that she was considering to conclude with versus a summation from me. I don't know how the board would view that. I don't know if the board would view that as testimony or, so I would like the opportunity to just ask the applicant, and then maybe you can consult with your board attorney as whether or not you would accept that.
I don't think it's a problem. I think we'll provide our professionals and members of the public just to question Mr. Stiers here on any questions they have. Ms. Sarmat or Mr. Burr, are there any questions that you would have regarding Mr. Stiers' testimony?
I don't believe I have any questions at this time.
Okay.
Thank you.
I don't either, Mr. Chairman. My questions were responded to with Mr. Kirsch. Thank you.
Very good.
Just go to the public.
Go to the public, yeah. Are there any questions from our public for Mr. Stiers? Please come forward to the lectern. And if I could just clarify, this would be questions pertinent to what we just heard.
There will, there will, very soon, there will be public, broad-based input, very soon.
Hearing no other questions, we can move forward.
So I think if it's your preference, Mr. Chairman, we can open it up to public comment, and I can put a closing statement or a summation at the end. Ms. Haas has deferred to me, so I'll end with a closing. I don't know if you want me to do that now or after public comment.
I think we could allow the public comment at the present time.
So just say this is the broad base.
Good evening.
Please
Name is,
name and address for the record.
Paul Vetter, 148 Chestnut Street. Yeah, I'm hearing a lot about lateral pipes going here, going there. I've been there about, give or take, 50 years. I've seen a lot of storms and heavy rains. There's 4 storm drains right at the corner of Lot 12 and Lot 11. They can't handle the rain. It floods there in that low spot. We've had to already pull the cars out. There was water up to the rocker panels. And if you walk towards Perry Street, a little ways up, and look down toward Lot 12, go up to the north and look down towards Perry Street, Lot 12 is the lowest lot in that whole street of Chestnut Street. And that water collects there. 4 storm drains can't accept that water. And then you got a ditch coming from Linden Street between House 150 and 152. It just can't handle it, and where the water goes on the east side of the road, up over the curb, right through that 12, Lot 12. Through the Harpovites, through where the swimming pool used to be, and right into Raritan. My friend used to own that house. I've seen it numerous times. Nobody has talked about this. And it's going to be a problem. And my house, I mean, like I say, 50-some years, I got a 10-foot by 8-foot basement just for the furnace. Never had a problem with water for about 5 years. They built a house 150 next to me. I started getting water, had to put a sump pump in. They disturbed the water level. So I get a lot of water, not a lot, but it runs a lot. When I get heavy rains, it super runs and runs and runs, that sump pump. I got a spare on the shelf because I know if it goes out, it's going to be 12 o'clock on a Sunday. So there's some things you've got to send somebody up there and look at that situation. I think you're asking for problems, especially with that water. It's terrible. I mean, you could see the dip in there. It's
When you refer to the dip, you mean existing lot 12
is the lowest lot.
is where water is collecting.
Exactly.
And it takes a period of time after a storm before it dissipates from there.
Yes. I mean, not just a trickle. You're talking almost 2 feet. It collects right in that basin. And actually, that's what it is, a basin. But to visualize it, from what I'm trying to explain it, I mean, you always just go there and look, and you'll see it right away.
I have been in your neighborhood a couple times. I did notice the double catch basins. And yes, the doubles.
Yeah, right.
And I conclude that there's a lot of water through that neighborhood.
And I'm just bringing it to your attention because I hear nobody talking about that situation.
Well, I think we've discussed it not in the specific term that you've brought to our attention, but that's the reason why I'm so concerned about, when we talked about the 57% and the 13%, it'll be if approved, a 32 and a 32, that is a big determinant of, is there anywhere for the water to go? So even though this is new information for us, overarching concern is, where does the water go? So it's definitely been a substantial focus of what we've been talking about.
And I would just real quick bring one more thing up. The first meeting you guys had, I was on vacation, I missed it. I went to the video, I watched the replay. The previous owner, like I say, was a friend of mine. He went on some hard times. Now, the new owner comes in and made a statement to the board about them being pigs and living like pigs, and had 18 boxes of garbage they took out of that house. I don't think that's right, what she said. And that shows me and tells me what kind of person she is. So, do I get the vote on this here for this variance, or just the board? No, well, okay. Well, anyway, that's all I have to say.
Thank you very much.
All right. Thanks for your time.
Anybody else?
So, my name is Cheryl Rakety, and I live at 153, which is lot 11. So I will say, in some degrees, I like the fact that you're going to clean up the eyesore that I have to look at every day out my window. That backyard is horrendous. But in other aspects about it, I am concerned about my property. We do have a big lot, and we are high. This house will be pretty close to us. I like the idea of you putting in that fence and giving some more greenery. I did hear about you moving those arborvitaes, which is good, but there are existing trees at the back of that lot. So, and by moving the arborvitaes, you actually will be taking out the probably 6 to 7 fruit trees that sit at the back of that lot as well. So actually reducing the number of trees in that section. I will echo the comments about the flooding. Our house is only 5 years old. And when we did have the big storm, within approximately 5 minutes, there was 2 feet of water across the road. I had to wade across from the neighbour's house. It came above my knees. I went into my house and my basement had 2 feet of water through it. So in a worst case situation, it's not coming from the creek, it's not coming from the Raritan River, it's coming from these drains not being able to cope. So I get that Hurricane Ida was a 1 in a 100-year storm, but these are happening much more often. So my biggest concern is I don't want to have to spend another $30,000 again to repair my basement, because of the fact that the neighbours' drains cannot cope with this, because the city drains cannot cope with the amount of water that's coming across from the back streets and collecting there. So if you have to walk across the street and it comes up to here, you can see how high this is? That is a lot of water to come down and flood the property within 10 minutes, and there's no way that any sump pump can cope with that. So that's my comments. I hope you take into consideration that this was likely to cause a loss of value of my property, and also in some degrees, I'm likely to be flooding again and again in their basement. Thank you.
Thank you.
Yeah, my name is Gene Jaworski. We're lot 14 next to lot 12. And we had voiced...
State the address.
145 Chestnut. We had voiced the same thing, the concerns, the flooding. And we'd noticed that, over the years, we've been there almost 30 years, you didn't see this kind of flooding, some pumps and everything. And just with all the building going on recently, there's many, houses, the lots have been changed. There are bigger houses being put on there. So we've noticed it over the years. More flooding, the sumps are kicking on, more water coming in, and you can see that the yards are getting more saturated. And, we listened to the testimony, we thought the same thing. Maybe that's why they went to 100-foot lots a while back instead of 50. Maybe they realized the problems they were having, wanted to avoid it. And we've seen it with the houses being built on the street now, how it is picking up. Trying to think, let's see. One thing they said, too, about the way that lot was built, the one house was way to the one side. And they, would say, was that a mistake or not? I said, did they ever stop to think that maybe that wasn't a mistake? That was put on the side, so you would have a yard to play with and everything like that, for the kids. The other being, it is the lowest spot, it does flood. You didn't want a house there where it's gonna flood. And like they said, a foot, 2 foot, it all goes there. And whether you put a house, direct the water to the street, the back, wherever you're gonna do it, it's all gonna go to that same sewer system, right to those pipes, where the water can't, you know, the brooks just can't take it, the sewers can't take it. It's gonna build up. We even have sumps that drain into them. When that water backs up, it comes into your basements, your sumps won't empty out. It's just gonna get worse if you keep doing it. And, you know, it's like you say, if you allow this to go through, what's to say other lots? Why can't we do the same thing? Or why can't we only have, you know, 7, 8, 9 foot variance? You know, you could be opening up a can of worms too. I do have a letter here too from Anthony Guida, 7 Over Drive in the back. He was the one that was concerned about the water because he's directly behind him.
Yeah, I don't know that that's, you really can't read someone else's letter.
Okay. He was curious because they had a graduation to go to. He was upset he couldn't make it tonight, so he figured the next best thing would be to have a letter, and he'd signed it and everything. Whether he could give it to you, where you could see it, I don't know.
I would also object to that, just because he's not here for cross-examination.
May I ask a question? Is there material difference between that letter and what he has previously stated to us, or is it more a summation of what we've already heard?
It's probably a summation. I think, you know, he just brought up the same thing that we were talking about. Like you said, that missing tooth where, you know, it didn't look, like as you drove by, you saw the swing set, so it didn't look like, hey, there's something missing here, we need to put it there and that. But I think it was probably basically a summation in it.
Okay, thank you.
Thank you. Anybody else? Okay, seeing none, I'm going to close the public portion for general commenting. Mr. Silbert, I'll hand it back to you.
Thank you, Mr. Chairman, and I'll be brief with my closing statement. So, obviously, we've been through 3 hearings thus far. The board and the public can appreciate the time that went into this, the cost that went into this, and we've demonstrated each and every hearing a continued willingness to address the board's concerns. Again, hearing after hearing, to the point that, and I want to make sure it's very clear that if this were to be one lot, you would have a a pre-existing condition with lot coverage, where I know it's only 0.5%, but it'd be over the 35% permitted. And because we listened to the board and we addressed the board's concerns, we came back at the 3rd hearing with a plan that is now conforming with lot coverage on both lots, specifically to address the concerns as it relates to drainage. Again, the board knows the background, and this isn't to the variance relief we're seeking, but Ms. Haas is a single mom looking to raise her family. She's a long time, she sent all of her kids to Bridgewater High School, and she has a track record of success looking at the improvements already made to the house on Lot 13. I don't think any of the testimony that Ms. Haas gave was meant to in any way hurt the previous owner. It was more to demonstrate the work that Ms. Haas put into remediating and renovating the house on Lot 13. So if she was speaking, I think she would probably say that. But we heard testimony from our planner that what's being proposed is not at all out of character as it relates to the surrounding neighborhood. Our planner testified that approximately 90% of the lots are undersized. And the fact that if my interpretation of the Oprah response is accurate, I think it speaks volumes that that approximately 90% of the surrounding neighborhood still has undersized lots, even though the R10 zone was established going back to 1977. So this is obviously a very unusual case, and unfortunate for Ms. Haas that we're here before the board, which would otherwise have been a simple variance application if not for lot merger. But we are dealing with lot merger. We are here, and we've done everything we can to work with the board to create an application that was that was an improvement to existing conditions. So I'll conclude with that. And I thank you for the board's patience. Comments from the board, although, the applicant wishes that we could have kept the garage, it has created an improved plan as it relates to the township's ordinance and township zone plan. So thank you.
Thank you, Mr. Silbert. Ms. Sarmet, are there any outstanding items from your report that need to be addressed?
I don't think so. I appreciate the comments and I appreciate the research that was done based on my feedback at the last meeting, particularly related to kind of the background. It's unfortunate that that there is no history. And in my own research, the one thing that I think, and Mr. Silbert had just repeated it, which kind of jogged my mind on it, is this application was opened up describing the merger doctrine as kind of the reason why we're here for this application, why there's a subdivision. And in just trying to do some of my own deed search and land record history on the property, I will note that the property was under, or both properties technically, both lots were under common ownership for at least back until 1949. That's as far back as I got on deeds. And so I don't want to just chalk it up to the merger doctrine, because this site has existed this way for 75 plus years. So I just think that's important for the board to, recognize. Thank you.
Mr. Burr, are we okay with the testimony?
I do not have any outstanding issues at this point, Mr. Chairman. There's obviously been a number of plan revisions. There's been a number of conditions or potential conditions agreed to by the applicant, but as far as outstanding issues from our engineering memo, I don't have anything else. Thank you.
Thank you, Mr. Burr. Any other comments from our board?
I have a question. What is the timing on this project? More specifically, is time of the essence here?
So the minor subdivision lot and the deed, there is a time restriction just based upon the MLUL. I believe it's 180 days after the memorialization of the resolution. If that puts anything into perspective, and then that's when we would proceed forward with pulling permits. So you're looking at more than half a year before any types of permits would be pulled.
Oh,
I'm sorry. Let me. That's the deadline. I haven't done too many projects where the applicant's been able to meet all the requirements and go through compliance and file a plot before that 180 days. So that's why I said that it is the deadline. Craig corrected me, but that's usually approximately how long it'll take for the subdivision to actually take place.
okay, that's the regulatory requirements, right? How, can I ask, does the owner have pressure to get this involved? Is time of the essence for the owner, aside from the regulatory part of it?
Yeah, the answer is yes. Usually developers try to move, unless it's something unorthodox, they're usually trying to move as quickly as they can.
I would say she would get going right after we comply with compliance at the town, or with the planning and engineering department.
Mm-hmm.
So it'd probably be a few months.
Okay.
Mr. Chairman, I'm sorry, are you finished, Jim? Are you finished? I'm sorry.
I'm done.
Okay. Are you looking for questions or comments?
Just comments.
Well, I thought questions.
Well,
Well, I mean, I actually have a question that may inform our discussion. So did you have a comment or a question? Okay. Maybe my question will help the commenting, because my question is not to put Mr. Peck on the spot, but I'll put Mr. Peck on the spot. This neighborhood, many neighborhoods in Bridgewater already have far too much water. Whether we leave the existing condition or whether we build as is proposed, in either case, there's too much water. According to the testimony, the situation on these two lots will be slightly improved, but given the whole neighborhood and the vast amount of water, it'll essentially, there's a lot of water and not a lot of places for it to go. I guess my question for Mr. Peck is, do we hold this applicant responsible for that situation? Or do we not hold the applicant responsible for that situation? Because either way, if we build it, there's too much water. If we don't build it, there's too much water. So how do we weigh the level of responsibility that the applicant has for a condition that is neighborhood-wide in terms of all this water and all these homes that are built in such a way that there's just not all that much place for the water to go?
The general rule is that you can't penalize an applicant for off-site conditions that are out of their control. Now, if an applicant's going to be exacerbating some of these conditions, then that could be, that would be a consideration. But you can't, just the fact that, there's heavy traffic in the neighborhood, or there's an excess of stormwater in the neighborhood, you can't penalize the applicant for those conditions.
Okay.
Any other questions, Mr. Pappas? I think you had one.
I don't have questions. Were you looking for board commentary? Okay, so if I may. During these hearings, I've listened a lot, and the two witnesses that I most going to comment on are the applicant herself and the planner. And for the reasons that Councilman Kirsch and Mr. Peck mentioned, I'm not going to dwell on that because I think they have made improvements regarding minimizing problems with lot coverage. But for me, it's the bulk standards: side yard, lot size, width of lots. This is an R10 zone. I'd asked the applicant a question. She bought the property in 2019. The R10 zone existed. She either was informed of that or wasn't, and that's not the board's responsibility to inform a property owner what the bulk standards are for a property that someone purchases. The applicant's planner's testimony did not establish, in my view, any substantive rationale for granting of the bulk variances. Applicant's planner made numerous statements where he offered opinions about and when questioned, he admitted that he had not undertaken any research regarding the creation of the R10 zone, nor did he give any testimony concerning the designation of this neighborhood in the R10 zone. The applicant's planner's testimony, when he was questioned about the information about how, if there were any other properties subdivided creating 50-foot wide lots, he didn't know. The existing lot is in block 150, lots 1, 2, 6, 7, 8, 9, 10, 11, and 16 are all conforming to the R10 bulk standards. These lots are also in block 150 as the proposed or the subject property is, and these lots that I've mentioned are in the same block, north and south, on the same side for the most part of Chestnut Street. The proposal, as the applicant's planner said, is a better zoning alternative, and that's a direct quote. I disagree with that comment, and I don't think his testimony didn't substantiate that claim. It was a very broad statement without much you know, I viewed his statements as dismissive and disregarding the work that was established to create this zone in Bridgewater Township, as well as designating this part of Bridgewater as the R10 zoning district. And so for that reason, I'll be opposing the application. Thank you.
Mr. Pappas. Any other general comments from the board? Have we satisfied all conditions of request?
I mean, they've put on all their testimony. I mean, once the board deliberates, I can go through with all the various conditions that were offered. But
Okay.
Mr. Chairman, I just wanted to clarify one more time. I think I like Councilman Kerr's question way he proposed it. So basically, I wanted to confirm it one more time. So condition of the flooding was there before, and now at least with their allocation of the square feet, it's actually slightly will be improved. So whether it is 2 feet water or 3 feet water, we are going to see the same thing, at least approximately same thing, unless there is some disaster again happen. So as Mr. Pack says, that is not the applicant responsibility. Am I hearing correctly, Mr. Pack? Okay.
Yes.
Thank you. That's what I want to know.
Thank you, Mr. Chowdhury. With that, we'll close the public, we'll close this portion of the meeting. We're going to open it up for deliberations at this time. Mr. Atkins.
I feel kind of conflicted with this application, I do have to be honest, because on one hand, I feel like the applicant has been very responsive to our concerns, but on the other hand, it doesn't seem that there's any precedent since we have, in recent history, to split a zone to split a property in the area, especially given that this property has been under joint ownership, both lots, for about 75 years. Although this seems like it may be a slight improvement to the impermeable surface of the area, I'm not sure that it would be enough to address the board's concerns.
Thank you, Mr. Atkins. Mr. Magura.
I am sort of conflicted here. And I do appreciate, really, the residents coming out to talk with us. Some of us weren't fully aware of how bad the water problems are. And I'm not sure you've contacted the township with these problems, and perhaps, we can suggest a point of contact. You've got these problems that are outside of this project, you might say. The water running down the street, I've been there, but not during rainstorms. I could see where that water might not have a place to go. But I do appreciate you coming here and expressing your concerns. Really, I understand that. Okay. So, but the board has indicated we didn't know how bad it was until tonight. On the flip side, you've got this property owner with this undersized property according to the zoning, and that's where I'm also conflicted. This property was there, and then the zoning came afterwards, increasing the size of the requirements. And I have a problem with that. But it's a law. It's part of our requirements in the township. The side, the setbacks, coverage, it's all part of our the requirements of the township. So I'm having a hard time with this right now.
Mr. Wang.
Thank you, Chairman. I was absent from the first hearing, but from what I heard, in these two hearings, on one side, I think the applicants have been modified or improved the application. Though, to me, I think that they are really at the beginning, there are a lot of variances. So the other side, I really struggled with the stormwaters, where the water can go. This is on the border of two townships. So, if in the same township, maybe the other side could coordinate, all efforts from different parties. So from two townships, I don't know where the water is going to end it. Again, this is not a pretend responsibility to cure the problem, but, building another home on the other side did give me some concern. This is what I feel.
Ms. Chartwitz?
So I feel the same as mostly everybody else. I appreciate the applicant's willingness to work with the board for all of the modifications, for all the changes that you've done. I do understand that coming from a real estate valuation perspective, that the desire to subdivide the lots would be what we're looking for, the highest and best use here. And if you're thinking about the rules of the highest and best use, it could be physically possible with the changes. It could be maximally profitable, financially feasible. But is it legally permissible, which is what we're here for, and it's not as it stands. So Mr. Silbert brought up, if this was one lot, speaking in the hypotheticals, like if this was, we wouldn't really be having too much to deal with, but it's not. So if we're thinking about the hypotheticals and moving forward, hypothetically, if this were to happen, what else could happen? And Mr. Peck mentioned we can't penalize the applicant unless it exacerbates the situation. However, we don't know. It could possibly exacerbate the situation. And we can almost all see the writing on the wall that it would, because we all, residents here, I'm a resident, obviously, we've all seen that over time, the situation with water and drainage has gotten worse. So we can only assume that it would exacerbate. So in light of the public comments tonight, and in good conscience, I don't feel like I could support the application.
Mr. Chowdhury?
I'm going for, because we cannot penalize applicant, I think everybody has a right to build a small house of their own dream. So we came to this country at least to, have that dream. So I would not like to penalize the applicant at all. We know because of the reason that the stormwater condition will be same before and after. Even now, at least by mathematically, as the engineer of the township says that it will be slightly better. So I like to give the opportunity for the applicant.
Sikora?
I actually was probably one to start with that was pretty against the application, to be really honest. And I appreciate you coming back today and making all of the changes. I mean, our concerns were side yard setback, privacy to lot 11, which is very important to me. I wouldn't want somebody right up next to my home or ruining a tree that's beloved in the area. Stormwater management, the willingness to remove a garage that you just spent a good amount of money on renovating and fixing up, moving the shed, moving the trees to the back of the property, adding a privacy fence. I actually look at that lot right now, lot 12, the vacant lot, but lot 12, and I believe that a home on it will be better than what is currently there. So I'm actually inclined to approve the application with the expectation of the privacy fence, the moving of the side yard setback, knowing that I completely agree with what stormwater management, I have water issues as well, and I completely understand them. I don't believe from the testimony, I'm no expert, but from the testimony that there will be conditions that are worse than there are now, knowing it has been slightly improved. Yes, so I'm more inclined to approve.
Councilman Kirsch.
I want to compliment the applicant for certainly hearing everything, working with this board, and coming up with a proposal that is certainly much better than where we started. I want to just clarify the way that I'm looking at this, which is, and I stated this earlier, we are essentially operating like a zoning board, even though we're a planning board, because of the subdivision. So I spent 8 years on the zoning board, so pretty familiar with the thought process, particularly in this municipality. And what I typically do is try to break it down, to component parts. And where it comes down to for me is, really, is this property viable for a house based on particularly the side yard setbacks required? Given that there's no house, if there was a house, if it was some old dilapidated house, and someone came and said, we want to invest in the neighborhood, we want to make it better, but we need to make it 2 feet wider this way or 3 feet wider that way. To me, that's a fairly compelling argument. In this case, the 40-foot is practically impossible. So to me, I'm focused on the 15 and the 15. You met the 15. So now the question comes, are we going to enforce a side yard on the side closer to the house, or are we not? And candidly, the result of that answer either gets us to an approval or causes us potentially to not approve. And, I know the planner's testimony was mentioned. It would have been much more valuable to hear perspectives of the whole neighborhood, what's going on with side yards. We didn't hear that. We just kind of heard, wouldn't it be nice to put a house here? That's kind of what I heard from the planner. The other thing that I come back to is that this property was bought and the conditions should have been known that there were two, they were merged lots. And, one of 3 things could happen. Either, leave it the way it is with essentially a very large side yard, knock down the existing house and, build a larger one in the middle, or what's being attempted here. And what I keep coming back to is, candidly, either answer could be justified. And I guess to me, without a compelling 51% on one side or the other, to me a 50-50 says the case was not made. And so, again, I think you got to go 51%. I think a 50-50, it could go either way. In a case like this is not good enough. With appropriate appreciation to the applicant, the time, the money, the effort that's been put in, I think we needed to hear a little bit more from the planning standpoint, which we didn't. I'll be voting no.
Mr. Pappas, do you have any additional comments? It's difficult for me to simply echo all the sentiments that I've heard here this evening. I myself received the packet and I looked through all material. We all studied it, and originally it was very difficult to say that what was presented originally was an improvement. That was what was going through my mind, and I said, this is not an improvement to what's there. But you graciously returned, and we've been here for 3 hearings. We've learned quite a bit about stormwater mitigation. We've learned quite a bit about lot coverage, things that some of us on this board, we've really done a deep dive this time around. I had a lot of issues myself about the neighborhood transition from some of the smaller lots to the larger lots, and I think a lot of that by this meeting this evening was mitigated. I felt as though the transition was met, you know, by coming back here this evening and changing the size of the house and removing the garage, removing a portion of the driveway. So in my mind, things are starting to work with stormwater mitigation, you know, breaking things up a little bit, allowing for a little bit more of pervious coverage as opposed to just straight sheet flow. So things are starting to work in my mind. But then I'm here and I'm thinking, I'm hearing the public's concerns, and I have my own concerns about stormwater. And I ask myself, is this still an improvement on Lot 12? I'm not that concerned about neighborhood density anymore. Like I said, I think the proposed home was an improvement. I think putting a large home, as Ms. Sikora mentioned, I think, believe it or not, that would come with its own host of problems as well, putting a much larger home on over 2 lots. So I'm not so concerned about that either. I think what this comes down to this evening is that Lot 12 is on the lowest point in this neighborhood. And I'm having way too many questions this evening to support this application. However, the work that has been done to bring us to this point, I have to commend Ms. Haas. I would like to make this work, but for me this evening, this just will not. I have too many unanswered questions. With that, are there any other comments?
Okay. Perhaps this is out of alignment. If the zoning were changed, would that change my opinion? And secondly, we have a meeting tomorrow on the master plan for the township. What if? And those answers, like, you know, are not really, I'm not seeking an answer right now. I'm just making comments. That's all.
Well, I mean, just to manage expectation for tomorrow's meeting, and by the way, everyone who's in this room should be encouraged to attend because it is a workshop where we're going to be presenting the current work on the master plan. It's still a work in progress, although that doesn't mean it isn't close to finished because a lot has already been done. You know, these are exactly the types of questions that we're asking: is what do we want this community to look like? Now, just to manage expectations, though, you know, tomorrow is a workshop. There'll be some good dialogue. There will not be takeaway per se, and a final decision and a final document. We're still, you know, looking probably several weeks or even a couple of months away from that final document. If I want to understand your thought process. Are you suggesting that a redesignation of all or some of Bradley Gardens into something other than R10 is something that should be considered?
Again, having been through that neighborhood a couple times, I'm thinking that the R10 may be too much. Possibly it could be reduced, that street or the 8 or 10 houses in that area, reduced to something like R7000. With changes to setbacks. Or am I opening up a can of worms here?
I think, you know, as a suggestion, and this is just my suggestion, is when we're looking at the master plan, one of the recommendations may not be necessarily let's change the zone and change the minimum lot area, but rather let's do an analysis of the Bradley Gardens R10 zone and see how many lots are conforming, non-conforming, and then make decisions. So rather than jump to any conclusions, have the master plan make a more general recommendation about that so that any decision in the future can be informed by whatever that analysis determines.
Thank you, Mr. McGorry. Any other general comments? We'll need to hold a vote, I'm assuming.
Well, Mr. Chairman, and maybe Mr. Peck can weigh in. I haven't really been keeping score. I'm sure maybe some in the audience have. I haven't really been keeping score. And in addition, you know, we have an order of regular members who vote, and when we hit 7, we you know, right? Is it 7 or 9? When we hit 9, you know, that's the number of votes. So candidly, I'm not sure if the motion would be in order to approve because there's enough, or to deny because there's enough.
You can make it either way.
Before a motion is made, the applicant has requested whether the board would consider carrying the vote until the planning board has finished its review of the re-examination of the master plan based upon Ms. Magura's comment.
The master plan could take 4 months.
I mean, we're still months
And
away.
that doesn't mean that the council would then approve any change to a zoning ordinance. I mean, it could happen, but, you know, there's no definitive timeline.
Yeah, that would be like an indefinite kind of adjournment.
Sorry?
You could withdraw without prejudice. Withdraw the application right now without prejudice, which would not affect your ability to return. You know, res judicata would not apply.
Mhm.
There's no vote. I'm not going to tell you what to do. But do you want to take a couple of minutes?
Yeah, if you don't mind.
To review?
Thank you.
Please. We'll take a 5-10 minute recess.
Hi. I'm so tired. I was allergic to mascara.
Right.
Yes, here.
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 Yes.
Here. Mr. Silbert.
Mr. Chairman, I spoke with the applicant outside, and it's my position that in light of the deliberations from the board that they were considering potential zone changes as it relates to Bradley Gardens, it makes sense for the applicant to request an adjournment to the first hearing that's available in October. I think that'd be October 8th, given the fact that, again, knowing that the governing body may not be changing any ordinances. However, we heard planning testimony this evening, and if there are changes coming to this zone, the applicant's planner would like to address those changes as it relates to the reexamination of the master plan.
You'd have to renotice.
That's totally fine.
And just a general commentary, there are 8 eligible voters here this evening. There is 1 absence this evening, which would have made it 9. Therefore, had we had been in 9-person eligibility this evening, you would have been more entitled to having 9 eligible voters this evening. Any other comments, Mr. Silbert?
No, thank you.
Okay. Ms. Probst, that's October 8th? Okay. Mr. Peck, we don't have any dates available for, or ready for October yet at this time.
No, I mean, it's a, they
We're gonna
made a
renotice as
request,
well.
and I
Okay.
guess just, someone should make a
Make a
motion
motion,
to
okay.
just, even though I think it's on their own volition that they want to do this, but if you want to have a motion just
To accept the
to
request.
accept their request.
All right, I'll make a motion to
have a
accept
multi-month
the request to adjourn this hearing to potentially pick up where we've left off. Our first hearing in October scheduled for October 8th.
Second Tuesday of October. Yep. That's Councilman Kirsch, and that's Ms. Sikora. Could I have a roll call, please? Yes.
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 Yes. Mr. Silbert, we will see you in October.
You will see me again this evening, but
Oh, that's right.
Thank you.
Well,
sorry about that.
let's fast forward. Moving along, we do have a second application this evening, and that is for Gerardo Leonard, Mountaintop Road, Block 718, and who will be representing the applicant this evening.
Good evening, Mr. Chairman.
Good evening, Mr. Silbert.
Board professionals, members of the public, my name is Michael Silbert. I'm an attorney at the law firm DeFrancesco Bateman, and I have the privilege this evening of representing the applicant, Leonard Gerardo. This application is for major subdivision approval, together with requested relief for 3 bulk variances for property located at Block 718, Lot 50 and 51, as shown on the Bridgewater Township tax maps, more commonly known as 1926 Mountaintop Road. Subject property is a 3.78 acre tract, approximately. It is located in the township's R40 single-family residential zone district, and the property currently contains an existing single-family dwelling on Lot 50. The applicant proposes to subdivide the property to create 3 new lots. They're noted on the plans as proposed lots 50.01, 50.02, and 51.01. The existing single-family dwelling will be demolished, and the 3 lots will be used to construct 3 new single-family dwellings on each lot. As previously mentioned, the applicant seeks bulk variance relief to permit a very small departure from the minimum lot width required for the proposed lots, where the minimum lot width required is 150 feet, and the applicant proposes a lot width of 143.58 feet, 147.82 feet, and 141.80 feet respectively for each new lot. Each of the new lots would be in excess of the required minimum lot area by approximately 15,000 square feet. So just to be clear, the minimum lot area permitted for each lot is 40,000 square feet, and each lot is proposed to be either just under or just over 55,000 square feet. So kind of the exact opposite situation that the board was just pressed with this evening, where we're dealing now with oversized lots, however, with a dimensional shortcoming on the proposed lots. This application, as proposed, eliminates a pre-existing non-conforming condition on Lot 50, where lot coverage of 19.62 exists, and where a maximum of 18% lot coverage is permitted. And that doesn't take into account, to my knowledge, I'll have Mr. Stires confirm the township's steep slope calculation, where the existing nonconformity would actually be much greater. So with the exception of lot width variance relief, this major subdivision application is fully conforming with the township zoning requirements. I do have 2 witnesses this evening, Mr. Craig Stires, who was responsible for the preparation of the subdivision plan before the board, and Mr. Dougherty, the applicant's planner, who is here to address the de minimis relief being requested in connection with this application. A few points that I'd like to address before I call my first witness. So Mr. Stires will address this variance in greater detail, but to be clear, the lot area for proposed lot 51.01 is 54,692 square feet. After steep slope calculations, the net developable area is 42,553 square feet, not 39,712 square feet. That has to do with the contours used on the plans, which the steep slope calculations in the township's ordinance is very confusing. It was a point mentioned in Ms. Sarmad's report, which I can address later on in our testimony, but I just wanted to note that there was not actually a departure there. Another thing I wanted to point out is that the dwellings shown on the plans that were submitted to the board were meant to be conceptual and design only. They remain conceptual and design only. However, it's my understanding that the applicant, as a gesture of good faith to address some of the concerns with the neighboring property, agreed to locate the dwelling at proposed lot 50.01 in the approximate location as will be shown in a supplemental plan that Mr. Stiles will present to the board. Notwithstanding this agreement, to be completely clear and for the record, the applicant stipulates to complying with all setback, FAR, and improved lot coverage requirements, even after the steep slope calculations, which we can speak about with respect to any new dwelling to be constructed on the proposed lots. The building envelope is what the board should really focus on. This agreement about constructing the dwelling closer to the street on 50.01, again, was essentially made outside of the board's purview, but again, the building envelopes are shown to show what is permitted on each lot if the lots are to be subdivided, so as to comply with all of the township's requirements. Should the applicant or a future home builder one day wish to deviate from any of the township's ordinance requirements, they'd have to come back before, in this scenario, the zoning board and get further variance relief in order to do so. So again, I think I've covered that. All right, so as a condition of approval, the applicant stipulates to complying with all applicable stormwater management requirements and regulations. Mr. Stires will address this in greater detail, but an O&M manual will be recorded in connection with this application as it relates to stormwater management. And my last point before I call my first witness is that I wanted to make the board aware, and I know I've done this for the past couple of applications, and either sadly or fortunately, for me it's sadly, that I'll say that the reason why the applicant is proposing 3 lot width variances is based upon their meetings with the board's formal professional, Ms. Doyle, both before the submission and after the submission of the application. The applicant could have created 2 entirely conforming lots with a lot width variance greater than what's being proposed on one of the 3 lots. Ms. Doyle, at that time, thought it would be a better planning practice to present the 3 lots with very de minimis variances rather than showing 2 conforming and 1 lot with, I would still characterize it as de minimis, but more than what's proposed. So that's where this is coming from. The applicant gave consideration and thought to the application, remains open to commentary, of course, from the board and the board's professionals. If the board's professionals and the board prefers that the subdivision be done so as to create 2 conforming lots and a greater lot width variance for one of the 3 lots, we can certainly accommodate the board, but there was thought put into this. So I would ask, Mr. Chairman, that's my introduction, so if I can have my 2 witnesses sworn, that'd be great.
Thank you very much for your introduction, Mr. Silbert, and please have them sworn in.
We'll go Craig and then Mr. Doherty. Do you swear or affirm that the testimony you're going to give in the course of this hearing will be the truth and nothing but the truth? Yes, I do. And could you state and spell your name for the record? Craig Stiers, S-T-I-R-E-S. Great. I do. Okay. All right, state and spell your name. Thank you.
And Mr. Stiers, if you would be so kind to just put your credentials and academic background on the record in the field of engineering for the board.
I'm a professional engineer from the state of New Jersey. Testified before this board as early as tonight.
Your license hasn't lapsed as of the last 10 minutes?
The board have any objections to Mr. Stiers' approval?
No objection.
No objections. Please proceed.
So why don't you start by showing the board what you have there on the exhibit here. This wasn't submitted. This can be, but it's not colorized, right? Okay.
So that's colorized subdivision plan?
Landscape.
It's kind of a, yeah, it's called a landscape plan, so it's a compilation of everything.
Have at it.
As Mike said, lots known as 1926 Mountaintop Road, or block 718, lots 50 and 51. We have lot 50 on the left-hand side, 51 on the right-hand side. Mountaintop Road is along the top here, and then you have the slope going down, looking over the valley. The current properties are, lot 50 contains 85 The existing house is, as I said, located in this general area. So what we decided to do is, with the removal of the house, is to limit the disturbance of the property in the area that was already disturbed. So that's the reason for the location of these two houses. Then obviously with the third house, we just kept them in line. These two houses, which are the two westerly houses, were taking portions of the existing driveway even. So this portion right here is the existing driveway, whereas the end of it is the existing driveway going out to Mountaintop. The houses were again set on kind of the top of the ridge for the view of the valley, and the minimal grading to get the houses to tie in. You can see it's primarily around the house, and using the existing driveway, we tried to minimize the removal of the trees. Because of the amount of disturbance, so it disturbed greater than 1 acre of land. This was considered a major project for stormwater management, not because of the fact of it didn't trigger it because of impervious coverage, but only because of the disturbance. So what we had to do was either build a detention basin or come up with some other ways of stormwater management. And what we intended to do was to keep each of the stormwater management facilities located to each one of the lots. So by doing so, we did dry wells for each of the lots and pervious paving for the driveways. So that way we got out of the fact that we didn't need a big detention basin. We didn't need it spread over all 3 lots. We didn't need a big easement. We didn't need a homeowners association because it's all contained on each of the lots. Secondly, because of the major project, is the reason that we showed these houses in the first place. I mean, as Mike introduced, this is a subdivision. So why do we need to show the houses? That's the reason that we showed them. So we needed to show the impervious coverage, how we were going to address the impervious coverage, how if there's groundwater recharge, if there's water quality. We had to address all of those factors, of which we did on the individual lots. Since we've submitted the application, and prior, as you recall, we were supposed to start on the 7th. And between the 7th and the 21st, the applicant received a letter or was contacted by the neighbor to the west, concerned mostly about the westerly lot and the location of the house. Since that time period, he has had discussions with the neighbor, and what we've done is come up with a secondary plan.
You can introduce this as A2, the overlay plan.
Yes.
Okay. So this,
That is calling it overlay?
Yeah.
Overlay alternative plan?
yes.
So what we've done, essentially, obviously the subdivision doesn't change. We've moved all of the houses approximately 100 feet towards Mountaintop. So you can see this is where we originally proposed it, the new location, originally proposed, same thing. That also will reduce the impervious coverage on each of the lots. What we showed originally was a worst-case scenario. So what would happen is if the application were approved, you have a worst-case scenario. It can't get any worse than that unless they came back to the board and got a variance. So in this case, now we're reducing. Instead of getting bigger, we're reducing. So you can see how much the driveways are being reduced on each of the lots. More importantly, I think, I wasn't personally involved in the discussions, but the concern was the view from the neighbor's house of the valley, so that you can see that, I mean, that this new house location is actually in front of theirs. So they would have a full easterly view.
Where's the existing home? Just
The existing home is in this location right here.
okay.
So, like I said, that's what we were looking to do originally, is kind of maintain that location. But because of the concern and what the applicant discussed with the neighbor, was to move this forward to alleviate her concerns. So hopefully, I mean, I believe she is here tonight, so hopefully we can address that, but we feel that we've done it, but I guess as the meeting progresses, we'll find out. But the other thing was, I think that was really it. The intent is for this particular lot on the westerly side was to maintain that grinder pump. It still has 4 years left of that license agreement. Once that license agreement were to expire, then obviously the homeowner would take over the full maintenance of that, and going forward, it would be theirs. The middle lot would also be on a grinder pump because it's still in that force main area. The one to the right would actually be able to connect in by gravity. There are a number of trees that we're taking out, so we're replacing along the slope. I know that at least in the past with Scarlett, she'd like to enhance that slope whenever she could, so that was the intent along the bottom here. And then also just kind of giving some privacy, we'd put the remainder along the property lines between each of the lots. I think that is it as far as the presentation of it. So if there's any, Mike, if I missed anything.
Yeah, I'm going to go through the report here. So you addressed the grinder pump.
The one, Bill, I'm sorry. We did I know there was a concern about possible high groundwater and testing related to this, the dry wells. We have done testing subsequent to the submission. No groundwater in any of the holes. We did approximately 14, I believe. So there was testing for the dry wells as well as potential house locations. So between those 14 tests, it looks like it would be, believe it or not, a good lot for recharge with the dry wells. So
the driveways in the overlay plan, those are still intentionally meant to be pervious pavement?
Yes.
And you already explained exactly why the applicant is using pervious pavement. The maintenance of those driveways would be recorded in an O&M manual?
Yes, each of the lots, because it is a major project, each one would have a operation and maintenance manual associated with the dry wells and the maintenance of the driveways. Again, I believe it's got to be filed in the clerk's office as well.
Did you speak about any drainage swales that exist on the property?
There are none.
Okay, so if there are, we can obviously, there's a comment here in Ms. Armad's report that it be a condition of the approval if the applicant be required to clean out and maintain any drainage swales. So if it's applicable, we'll comply with that. How about wetlands? Are you aware of any wetlands on the property?
No, and we also looked on the DEP as I guess it's a website. There we go. You can go onto that website and see if there's any indicators for wetlands, and there was no indicators, so we didn't pursue anything further after that.
Do you think a letter of interpretation or report should be prepared to ensure that's the case, that there are no wetlands?
Typically we would have, Ed Cook is our wetlands consultant. He could walk the property and issue a letter if the board were so inclined.
The board will accept a letter, and I'm referring to comment number 4.1 on page 9, as it relates to stormwater management in Ms. Armad's report. If the board will accept that from our professional as far as wetlands are concerned, that's what we'd like to be able to provide. So is there, speaking about the grinder pump for a moment, we don't know the condition of that grinder pump right now, right? To your knowledge, it's working the way it should, or?
I don't know. I know the house hasn't been occupied for a number of years.
Okay, because there was a comment that it should be replaced, but if it is at the end of the term of the grinder pump agreement, if it is in good condition, would you recommend replacing it, or should?
If it's in good condition, personally, I would use it until the end, the termination of the lease or the license agreement.
Okay, but then at the termination of the license agreement,
They would fall to the homeowner.
fall to the homeowner. Okay. Any public improvements associated with this subdivision?
No.
So other than the standard maintenance bonds, do you think there would be any other required bonds associated with this?
Just with the trees. Most
Okay.
likely. That's it.
So there's a comment here about a developer's agreement, just because there aren't any public improvements. I know this is in every report, but I always request that if there's no public improvements, that the conditions and requirements on the applicant just be included in the resolution in lieu of a developer's agreement. Did we receive any comments from fire, police?
I think that was.
I don't know if I did. I don't think we did. I'm sorry. I don't think that they had any concerns.
No comments. No exceptions for the fire.
Okay. Yeah, so that's on the cover page here, you'll notice.
Please, no comment.
That's all I have as it relates to Ms. Sarmad's report. I'm just looking through Mr. Burr's report. How about sidewalks? Did you speak about sidewalks?
There's nothing on Mountaintop.
Okay. And, yeah, nothing, no sidewalks whatsoever on Mountaintop? No. So you don't think that a contribution makes sense for this?
I honestly, probably not, no. I mean, it's from one end to the other, there's nothing, so.
And are you aware of any easements?
No, other than the license for the grinder pump.
Right, okay.
With number 6 for the drainage, the intent is to actually recharge all the impervious coverage, so the houses and the driveways would be recharged, so theoretically speaking, you don't have any impervious coverage draining off the property.
I can turn it over to the board and the board's professionals for further questions, but otherwise, the reports looked good from our end, that we could comply.
Except as otherwise testified to.
Yes,
Applicant will accept both the Burr and the Sarmad reports.
correct.
Yes.
Thank you, Mr. Stiers, for your testimony. Does the board have any questions?
Yes. Well, as soon as you mentioned pervious driveway, pathway, we all got excited. So, because we were talking about that one before. Now, I know for sure, probably I should not put my own expertise here, but there's several different areas of how you can make the pervious driveways. If you, please make sure that those are not breakable, and also take the maximum pressure from the different track or something, because once it is break, the pervious problem is that you can be, board may be approving it, but once it is break, it actually create more problem of floodwater than what you would not have. So kindly think about, because I know about it, that's why I'm telling you. I'm not recommending anything, I just wanted to let you know, because people do short circuit it and we always approve it and then things may go wrong. So you mentioned that 1 year maintenance.
No, it'd be continuous because of the operation and maintenance.
Yeah,
Okay.
So with the operation and maintenance manual, it would be a period, so, either brooming it or whatever, multiple times a year.
May I request you to at least consider, at least check one more time once the heavy rain comes in, because you will know everything with the first heavy rain. That is one. And also, I thought we talked about the pavement. That pavement is a new pavement, the front road, the main road, Mountain Road. Yeah, this one is new.
I think it's a couple years old, yes.
Yeah, so you'll have to dig it up. So you'll have to basically fix everything from end to end, and right, because it is 7 years of. Okay, I think last time we discussed about it, like, right, Mr. Chairman? Okay, thank you so much. Those are the two concerns, sir.
Mr. Stiers, will the well need to be re-inspected since it's been uninhabited for several years?
Ironically, when we submitted for will serves, we put it out there, obviously for water as well. There is actually water in Mountaintop now, so no wells at all.
Oh, well, okay.
So they would tie in publicly.
I had a question. If you moved up all the houses to not obstruct the neighbor's view, are they going to now be obstructing each other's view? Like, would it be better to stagger them all?
I mean, you can kind of see the general.
Yeah, I think if they're trying to look towards that.
What we tried to do was actually go from one side to the other, so they kind of line up with all the remaining houses. So it's more of a consistency along Mountaintop. And just to follow up with that, I think the biggest concern, at least with the neighbor, is this one. I mean, these can vary, but like I said, we talked to our client, and it's most economical for them to push them up as much as he can, which is, it's fine with us.
And the size, the approximate size of the front yard setback is now how much in the new location?
The required is 50, so I would estimate it's 75 feet or so.
Okay.
So this is 50. Yes, 75 feet or
Because
so.
before it was 177, you said you pushed them all up 100.
Right, so pretty good guess.
And you're still using what we call it, semi-pervious?
Pervious.
Okay.
So the theory is that the water drains through it. So if there's different versions, there's concrete, there's blacktop, you can use pavers. So say, for example, you had blacktop, which is everybody's most familiar with. What they do is they take the fines out of the blacktop. So now it's like almost like a honeycomb. The water drains through it.
Okay. But there's going to be less, so you're using that product, and there's going to be less of it. So the net result from moving forward is more grass.
Or grass entries, yes.
Okay.
Again, I always try and go on the worst end. I don't know whether it's good. Sometimes it's good, sometimes it's bad, but I want to show the board the worst case scenario.
Okay.
I think what we did is we showed the worst case to the neighbor, and that brought out the reason to pull it forward. So I think it was a good thing to show the worst case scenario in this case.
Okay. And the guidance that you got in terms of why each of the lots is proposed as they are, instead of having two conforming and one really not conforming, if that's a phrase, the feeling is a relative uniformity is more desired. It will ultimately allow a more even view of the neighborhood.
I agree with Scarlett. You get like I read the various lot widths down the street, you get more of a uniformity. And I mean, the other thing is to keep in mind is that, if this weren't done, you could put two 12,000 square foot houses on each of these lots, which to me, I don't think, going down Mountaintop, this is kind of the consistency right now. So to evenly distribute them and, both size and lot width, I think it's better because you also control the size of the house. So if you were to get bigger lot widths that conform, you're getting bigger lots as well, which ultimately leads to bigger houses. So you could have two big houses and then one smaller one if you do the two conforming and one not conforming. So I think consistency-wise, I think it works out better.
So consistency of size and location,
Exactly.
so that you have, fairly uniform side yards, so to speak. When you take half of the side yard of one plus the half of the side yard of the other, you're seeing a more consistent landscape as you're going down the street.
And coverage-wise.
Okay.
Because you're also, you're averaging the lot area, which ultimately goes to the coverage and the FAR. So
Okay.
it's consistency.
Okay.
So just because I was in the meetings with Scarlett, and the board can lend as much weight to this statement as they wish to, but she said that basically if you're from a street view perspective, it's very hard for somebody to notice a 3-foot departure when the lot width is 150 feet, or a 6-foot departure. But then if those numbers are increasing to say 20 feet, then you might notice from standing there on the street, you notice it on a plan, but you have a different perspective standing there on the street versus what the board is seeing on a plan.
Okay. And one more, I don't know if you mentioned it or not, the proposed square footage of each of these homes?
I believe the footprint we have here is roughly 4,000.
4,000 each.
But again, conceptual in nature.
It's very difficult to, well, it's not difficult to say what the maximum FAR can be, but it's difficult in the sense that the board or the township's ordinances, when they calculate for FAR, they don't count garage space or they don't count attic space. I'm not specifically citing to the ordinance, but I think that's why it's difficult to say the house will be exactly this size, but what we are agreeing to is that we will comply with all of the requirements, so lot coverage, FAR, setbacks. That's what we would certainly agree to comply with.
Okay. And just going back to the comment about, somewhat evenly dividing these, I want to make sure that, Ms. Sarmad, you agree with that line of thinking. That, again, instead of having conforming, and really not conforming, you're better off having relatively even lot widths.
I would agree with that, yes.
Okay, thank you.
This is quite a wooded two properties here. How many trees are going to be taken down, and how many would be put up?
It's going to change with the plan revision.
Like a general estimate, do you have?
30-ish.
Yeah.
This plan, we had 30 removed.
Yeah, I drove up there.
And how many total on the two properties?
I'm not sure off the top of my head the total number. That's what. Yeah, that's what he did. Yeah. Right.
Mr. Atkins, you were asking about the total trees that exist, right?
Yeah, just an estimate, and generally how many trees are on the two properties, or an exact figure if you could offer
I
that.
know we have, with this plan, the original plan was approximately 30 to be removed. I'm not sure of the total. Like I said, I'm probably 3-4 dozen, maybe more.
Thank you.
It is wooded. It's open, if that makes sense. It's got a good canopy to it, but there's not trees every 5 or 6 feet. There's probably it's it's not woodlands, but it's a healthy lot. Let's put it that way.
Mr. Steyer, speaking to the trees, we agreed to comply with the report, but there was a mention of conservation easement that would also maintain trees in the rear of the property.
Yeah. What we have done in the past with Scarlet, again, sorry for keep referring back, but with other projects, especially relating to the slope and really the top of the mountain there, was to create a conservation easement that would be equal to the rear yard setback. So, you can see that we're supplementing, but we would put a conservation easement along that back line, because you really can't put anything in there anyway. You can't, that's why you have the setback. So we would respect that setback by creating a conservation easement in that. So that's roughly the back 85 feet, I believe, 75.
Mr. Chairman, I have questions. Mr. Stires, you spoke of the existing house. What's the square footage of the existing home?
I think the footprint is probably around 6,000. I said it's mainly, when I was out there, when you go in the front, it's a one-story, but as it comes out, you have the basement as well.
And what was the square footage of the proposed homes?
Footprint was roughly 4,000.
So we have two lots, lots 50 and 51. Do you know, are they under common ownership?
I believe, yes.
But they're not subject to lot merger.
Why is that?
It's just a lot width. It's not under, like, the total area. They're oversized lots. So it's similar in the sense that there's a dimensional departure from the ordinance requirements in terms of lot width, but these lots are actually way in excess of what the minimum required lot area is.
Well, they're fully conforming.
So when a
Right
lot,
now they are.
so when lots are adjoining commonly owned lots are conforming to the zoning, they do not merge? I learned something today. Pardon me?
When they're substandard and under common ownership, then they'll get merged.
Okay. When you,
Sorry to interrupt
Yep.
you, but just if the board approves a subdivision, they also would be protected against, if this were like the last application, the lots, of course, would be protected against lot merger if the board grants a subdivision.
right. Mr. Stires, when you were engaged by the applicant, did the applicant speak to you about this project?
Yes.
And did the applicant ever, in any conversations you had, consider building two houses on the two existing homes, two existing lots?
No. He mentioned building a substantial house on the westerly side and then further subdividing the remaining two lots. So that the larger lot would actually be an L shape to accommodate the lot size or the house size, and then two smaller lots to the east.
You mentioned that, I think 12,000 square foot house or something like that as was being considered. I think you also made some reference to that being out of character. You're saying that there's no other homes in this area that are larger than the existing home?
I would say driving down Mountaintop, there may be one or two that are further down, maybe down on Rose Lane. There's one house that I'm familiar with that is, substantially larger, but for the most part, on either side of Mountaintop, I think you have a pretty good consistency on both sides.
Were you present at the meetings that were referenced with Ms. Doyle?
The first one.
And could you describe that conversation again that's been referenced here? Give us your version of the discussion.
My conversation my conversation about the view from the streets happened after we submitted, and I went in to meet with her to get the application deemed complete, so that wasn't like a conceptual meeting. It
Okay.
Not at the second one.
Okay, so Mr. Cyrus, did you have any conversations with Ms. Doyle about this property?
Yeah, I mean, we had the first meeting just to kind of get a gauge of, you know, like Mike said, how to lay it out. But I think that, you know, I got the same take from it.
Could you restate that in your own words for me?
That the lots should be laid out evenly. So we were looking to go from 2 lots to 3 lots, and that the lot should be laid out evenly. She also brought up the street trees. As you can see, we showed 2 street trees, and to more specific, there are street trees along Mountaintop, and that we should really call these out as street trees. So rather than, you know, you take out an existing tree and put a new tree in, we would just theoretically designate street trees along Mountaintop. But other than that, honestly, it was pretty straightforward.
Okay, thank you. That's all I have for Mr. Stiers. Mr. Silbert, who are the other witnesses? Just the planner? The applicant will not be testifying?
That's correct.
Okay, thank you.
Mr. Chairman, just a brief question. Maybe this would also be addressed by the planner instead. So you could construct homes that are in the vicinity of 6,000 to 7,000 feet without having an FAR challenge. But realistically, given the marketplace, given construction costs, given people's preferences, the anticipation is that the homes would be somewhere in the vicinity of that 4,000 you mentioned?
Yeah.
Let me ask the question differently.
Speak for the owner, but I would say yes. I mean, that's kind of what he's conveying, yes.
All right, but let me ask the question a little bit differently. In your professional experience and estimation, given current the construction environment, you know, is the reason why someone would construct a 4,000 square foot house, even though they could build larger, is that's what the market is bearing right now?
Conceivably, yes. But
Can I piggyback off of that question and ask if the building footprint of the home is constrained because of the lot coverage requirements? Meaning you build a home that's X number of square feet, but you still need to build a driveway that can get to the home, and you want a patio and whatever. Right. I guess my question is, the footprint of the home is determined in part by other improvements on the property.
yes, and that's what I said earlier, is that by creating these 3 lots, you have better control over the size of the houses. Like I said, both the setback-wise, coverage-wise, and FAR-wise. And if the application weren't approved, you know, we're not before the board, and they're 1.5 times bigger potentially.
The reason why I'm asking this question is because you sometimes see, not necessarily in Bridgewater, you know, you're driving along and you turn a corner, you're like, oh my goodness, someone just built a convention center. And I guess the answer is, well, up to, you know, 5957, 6292, and 7001, somebody could build a pretty darn large home. But that, again, the economics of it more likely support something, still a very nicely sized home in the vicinity of 4,000 feet.
Someone could build that home, but then again, you get out of scale with the neighborhood. So say you build a home and then you go look to sell it. You know, for example, you know, your appraisals are based on all the number of houses in the area. So you get an appraisal. You know, I'm not saying I'm an expert at it, but I just went through and I bought a house. So I went through this whole thing. And the appraisals, they come in low, and all of a sudden somebody can't buy that house. So you have to be respectful. I mean, as a builder and as a developer or investor, you have to be cognizant of that as well. So I think we are kind of saying the same thing in a different light, I guess you could say.
Mr. Chairman, just one follow-up. Mr. Stiers, you talked about originally the thought was to have an L-shaped lot and then 2 smaller lots. What were the square footage of those 3 lots approximately?
I believe the 2 smaller ones met the 40,000 square feet, and whatever the remainder was. So maybe 100, I guess it'd be 120?
Would there still have been a lot width variance required?
Yes.
Thank you.
Any other questions? Mr. Stars, I focused a bit on Board Engineer Mr. Burr's question number 11. I think you mentioned that you did test the soils, and you testified they were, how far did you go down, 14?
Well, there was 14 tests. There are various places. There is a knob at the top here that was probably, I believe, 6 feet or so that they hit solid rock.
Okay.
Whereas back behind the existing house, they went down, I think, 8 or 10 feet. And there was no water in any of the holes. So as far as that concerned, and there was, like I said, we hit rock, and again, that's one of the reasons probably that the applicant also moved forward is because of the results of that. So it's multiple things, as far as economics and buildability as well, to get up and towards the front more, get off that knob.
So what I noticed on your site plan, Lot 51 had a much higher elevation toward the center part of that.
Yeah, the knob is like right here, yes.
So that's mostly comprised of rock and...
Yeah, I said they got down, I believe, we didn't do it ourselves, we had somebody do it, but I believe they said it was around 6 feet before they hit refusal.
Board Engineer Mr. Burr, I wanted to ask you that question. Based on those holes and test holes that they had checked, do you feel that that would have been adequate? We're having this conversation regarding stormwater from previous applications into tonight, and we're looking at the impact on soils and...
Well, I'm encouraged to hear that Craig said that he had favorable results, but I haven't seen the results myself. So one of the things I was going to ask is that they provide that information either by way of a separate submittal or documented on the plan set so we can get eyes on that. But I'm certainly encouraged by the fact that Craig supervised the work and said that they were favorable results. But I don't have any information beyond that.
Right. I also noticed on the site plan that there were several, or there was a few dry wells per lot toward the rear of the properties. How large are those sized for? Or what's the capacity of the dry wells and
They're based on the size of the house.
Size of- okay.
If there's a smaller house selected, or, the footprint's smaller, the number of dry wells would also go down.
Okay. And I'm assuming you would agree to any pre-construction meetings should Board Engineer Mr. Burr or the team would like to?
Absolutely.
Okay.
Yes.
Any questions for you, Mr. Burr?
I do have a few, Mr. Chairman, thank you. So Craig, talked a little bit about the typical home sizes, and you had mentioned this shows a plan reflecting around 4,000 square foot home footprint. So is that to mean that on a 2-story dwelling, the way this is shown now, you could be looking at a 6,000 or 7,000 square foot house? Is that?
Yes.
I just want to make sure I understand how you.
Yes.
They came up with it. Okay. So from my perspective, and I know as the board and you guys reviewed my report, a lot of my comments had to deal with the steep slopes, the hillside development ordinance, the stormwater management impacts. One of the appealing parts about this overlay plan is obviously moving it closer to the road, you're reducing the coverage. Presumably, you're getting further away from the steep slopes. Have you quantified what that means? Can you give us any numbers here as far as how much of a reduction this plan represents, or how far away you are from the 30% slopes? Just give us an idea of what, some of the improvements are.
As far as the actual numbers, I didn't get a chance to finalize them. That was kind of the last couple days, a little bit back and forth. As far as, you can see, these are the true steep slopes in this area, which is the southeasterly corner of the property. Behind the existing house is relatively level, whether they, in the past he leveled it off or whatever. It is relatively level in this area here. So yes, the steep slopes, we got 100 feet away, 100 feet more away from them just from the relocation of all the houses. So again, that knob is like right here. So anything behind that is going to, other than removal of the house, is going to remain unchanged.
So I heard, I don't know if it was you or Mr. Silbert earlier mentioned that this was an option, and your original plan was worst-case scenario. This was an option to address perhaps one of the neighbors' concerns. If the board was in favor of this option, and if the application was approved, how does the board memorialize the location of the overlay map, recognizing that it's going to come with reduced coverage or lower coverage, certainly no disturbance or maybe minimal tree removal in the steep slopes? I heard earlier that this is an option, but we're still going to comply with the zoning requirements, which to me, it doesn't really allow us to nail down the specifics of this plan. Is that fair? Does that make sense? Is there a way to craft an approval around this plan if this was the way the board was inclined, to make sure that we had, a certain limit on the coverage that's being proposed, for example?
Well, I think the steep slopes ordinance controls the coverage. As far as the location, I think maybe, if it's all right with you guys, is to increase the rear yard setback, at least for the principal dwelling. I mean, you can obviously do pools, and I don't want that restriction kind of placed on pools and things like that, but as far as the principal structure, maybe we can do it that way.
Yeah, I mean, my concern again is if the board's inclined to approve the overlay with the houses move forward, there has to be some protection from somebody coming in and saying, well, I'm allowed to do the original plan, and it's contrary to what the board's approval was. So that, that's something that I wanted to bring up. You had mentioned the pervious pavement driveway, and there being an O&M manual, an operations and maintenance manual for the maintenance of such. In your opinion, is it commonplace to expect a homeowner to maintain a pervious or porous driveway? Is that a reasonable expectation?
I should say it better be.
Have you
Just based on the rules, I mean, that's what you have to do. And
have you proposed pervious pavement on residential applications before?
Not specifically, no. On commercial projects, industrial jobs, we have, but I think Mike is mentioning that we did one up on Sunset Ridge, but where we put it was more the patio related than the driveway itself. Right. So the driveway has a little bit more responsibilities to it. So yes, you're right, but the rules are the rules now.
I understand the state accepts and endorses that
and we have to live with
product for addressing stormwater management, but the practical reality is it does require maintenance, and I want to make sure that if this is approved and built out, that homeowner knows what their obligations are.
Yeah, and no matter what we pick. I mean, we could pick a bioretention basin. We could pick, even the dry wells themselves. I mean, you put them underground, and then, as long as the homeowners forget about them, they're never maintained. So no matter what you pick, they have to know it. And, they can also hire somebody at the same time.
And Bill, we could also require a note on the deeds. In addition to recording the O&M manual.
I was going to recommend that.
But on the deed also to make reference to the O&M and that, the homeowners have a responsibility, property owners' responsibility to do this. And then it's on our system.
We can put that in the deed.
Yeah, if I may also add, Mr. Chairman, I think this is a very, very critical and important point that you mentioned, Mr. Barr, because since I know about it, distance, pervious driveways, if you do not maintain, it's make more mess than what you had the impervious driveways. So I'm glad that you mentioned that one, and as Mr. Pack says, I think if you can kindly add this, that'll be really good. Thank you.
I mean, when we do stuff, we always have that in mind and try and do the least amount of responsibility. Even on industrial and any kind of job, it's, you know, you have all these abilities, but practically speaking, as an engineer and knowing what's going forward, I'd rather make it as you know, I wish I could make it a detention basin, but
No, and
that's out the window anymore.
You're right. The way the requirements are set up make it very difficult to address drainage with just one component.
Yep.
You normally have to introduce a number of different drainage features to address the end goal, but like I said, that's somebody's responsibility. So, let me ask you a quick question, Craig, about the sewer. You mentioned there's an existing grinder pump on the existing home.
Yes.
Taking a look at the grading plan, and I just glanced at it real quick, if you were to move the homes and that becomes a condition of approval, moving the homes closer, it looks to me like you may have the ability to get gravity feed for your sewer to the street, so I would recommend you take a look at that. I know our sewer utility issued a memo that they had recommended replacing the grinder pump.
Yeah.
But if it's not necessary, obviously that should go away.
Well, that's the thing is from what we've gathered, I mean, you guys may have better records, is this is a force main until here, until this point right here. So I can probably get this one in, probably with an easement over this lot. So you have the east lot, the middle lot. This one's gonna be tough unless maybe put another easement all along the front of these to get into that last one, because it is deep. So we can probably get there. It's just a matter of easements through it.
Okay.
Yeah, I'd rather use gravity as well, if we could.
Last question has to do with tree removal. I think you mentioned you had 30 or 32 trees proposed to be removed under the original plan.
Correct.
Is it safe to say that by moving the homes closer to mountaintop, that you're going to be able to preserve some of the trees that were originally proposed to be removed on the sloped areas?
Well, as you can see, you know, we hit the knob. We were never really on the slope itself. So this area through here was relatively level. But to answer your question, yeah, I mean, anything back here is going to remain. Obviously, instead of removing here, there's going to be some removed where the new locations are.
Understood.
And we'll meet the ordinance as far as the tree replacement.
Accordingly. Okay, very good. Thank you. Thank you, Mr.
Thank you, Mr. Burr.
Follow-up question on the pervious pavement. So I have a commercial property that has pervious pavement, so I know the maintenance on it is not very fun. Question on township salts the roads, right? With normal salt, you can't put regular salt on pervious pavement. What happens to the edge of the driveway to the road it attaches to?
Well, the aprons are going to be, like your planner said, is within the right-of-way itself will be normal pavement. That's a good question.
And then other parts, not saying we did this, maybe we did. We've repaired areas with asphalt because a certain percentage can be repaired with asphalt versus pervious pavement if you've got a pothole or a piece that you have to repair. What's the stop on that for a residential home? Or how can we ensure that the homeowner won't repair areas with asphalt versus the pervious pavement?
Good question.
Is it a percentage or is it a?
I don't know
Okay.
that. I don't know that answer specifically, but you know, again, it's the nature of the beast. I mean, whether it's a homeowner or a business owner, what's forcing the business owner the same thing is, you know, and that's what Bill and I are talking about. It's in the rules, it's a great idea. But practically speaking, I don't want to hear this on the record, but it's a terrible idea. I mean, a lot of this stuff is just, when you go through and you think about the consequences, just like you're bringing up, all these rules have consequences, and we all have to live with them. But, you know, that's the nature of trying to control stormwater management. Everybody's got the concerns. We got to address it somehow, and, you know, they're not the greatest ones, but I have a different theory. But,
Yeah.
you know, I could digress for another hour if you want.
All right, same.
Mr. Stiers, for the members of the board that aren't aware of what the pervious coverage is, right, for the driveway, or how to maintain them, what's a typical maintenance on a pervious driveway? I understand there's a basin underneath.
Yeah, it's basically stone underneath. And, you know, the perviousness allows the water to filter through it. So that is the filter as well for not only recharge, but also water quality. And again, you have that honeycomb aspect of the pavement. You got to keep that honeycomb open. And any sediments or what have you, sands, they fill in those honeycombs, they fill in the voids, it becomes blacktop, just like you're saying. So, you know, it's almost like you have to have a small sweeper or a vacuum, and you got to maintain it.
It's normal salt.
Yeah, and salt, we had a job in Branchburg, and it was the year that they ran out of salt during the winter. Our client came to us, and they had the ruts of every parking spot, like 19 parking spots, nothing left. They had to put it all in again. So that's the part that, like I said, the rules, you know, they throw them in there, but
Thank you, Mr. Stiers.
reality is another story.
Yep. Ms. Sarmat, I wanted to give you an opportunity to ask a few questions.
It wasn't going to be my first thing to cover, but to segue on the pavers. I was just talking to Mr. Burr about, you know, why the pavers were chosen. And, you know, it sounds like the testimony is not that much in favor of the use of them. And I think it's a weak point on the application. And it is a concern because it's not going to be an engineer who's handling the pavers. It's not going to be a commercial property owner or commercial property manager that's handling it. It's going to be a homeowner who may feel hamstrung or may make decisions about their pavers in the future if they're feeling like it's a problem. Snow removal, you know, a driveway is probably has the most wear and tear. A patio, you know, you don't really remove the snow off it. You're not going to go outside and enjoy your patio in the middle of a snowstorm necessarily, but you're still going to drive on your driveway and want to enjoy it, or not enjoy it, use it to get out of the site. And I think, you know, using a plow or anything like that, it's also going to damage the paver. So there's a, you know, in the whole scope of it, it's a concern. And if it's for the purposes of meeting stormwater management for water quality, I really, really would emphasize that I think that a bioretention basin should be explored as an option for stormwater management. I really think that would quell a lot of these concerns.
And by the time you're clearing preservation of the existing basin, what's the difference? The property owners are going to go through the same things that you have with the pervious paving. You know, as far as plowing snow, you put a rubber blade on. That's the easy one. You put a rubber blade on the plow, it's perfectly fine.
Yeah, but every homeowner walks into a new homeowner walks into a home and doesn't think about those things, despite it being in the deed, despite it being in the documents. And the first time they don't put the rubber blade on, or their plow guy forgets to, that they hire, you know, you're taking out a chunk of pavers, and maybe you're filling it with asphalt. So over time, we don't know what this is going to turn into as far as actually achieving stormwater management. Because it's not going to be in this planning board's purview. It's going to be at the homeowner, and it's going to be on the honor system, essentially.
And it's the same with a bioretention basin.
Well, bioretention basin isn't going to be driven on every single day. Isn't going to be plowed in the winter. It needs to be cleared out, but it's a lot easier to say, okay, once, twice a year, have some a company go in and clear it out, hopefully.
Is there no other option?
I mean, we've used the dry wells already. So, you know, the other thing is, if we can get the dry wells to work on their own, because we've moved it so far forward, that could be an option as well. So we, you know, again, we were more concerned about siting it and kind of getting the rough grading done. But because this driveway is so small, maybe we can eliminate that as an option and just use the dry wells. So,
So the exhibit that was presented with the updated slope calculations, and then as a result, the hillside development calculations, I actually didn't receive a copy prior to the meeting, and so I didn't have a chance to review how that impacted, because the bulk table was impacted based on the hillside development calculations. And so specifically with moving the houses up as well, you're obviously clearing off some improved lot coverage if the entirety of the driveway wasn't, is the entirety of the driveway pavers? Or just a portion of it?
at this point, all of it is,
The entirety. And the proposed overlay here shows them as pavers as well?
yes.
Okay, so there's no impact on the lot coverage from the driveway perspective, is there? From the pavers being part of the driveway? Do they impact the improved lot coverage? Were they included in the improved lot coverage calculation?
Yes,
So they were.
yes.
Does that, from your perspective of being a major development based on the over 1 acre disturbance, does this lower your disturbance by moving the houses up as well?
The problem is the house.
The house itself is
Yeah, I mean, that's another reason, we were trying to get under the
threshold.
total disturbance of that 1 acre. That's another reason we kind of put it back here to see if we could condense it to under an acre, and we got close, but we didn't. So,
Okay.
you know, at that point, we kind of left it where it was, but, you know, again, with the applicant and, you know, working with the neighbor, everything moved forward, so.
So these, a lot of these unknowns, I think, will factor into what's the optimal design on the site at the end. And this is a subdivision application, but, you know, clearly the situation, the scenarios all matter too, because, you know, the original design of the driveways are, especially if they're all pavers, they're not the most efficiently designed driveways. There's some jogs in them, they're pretty long, like a lot more maintenance the longer they are.
Well, the three revised ones are basically street.
But, so my question is, the revised drawing, is that just another, you know, you called the first exhibit, the underlay, the worst case scenario. Is the overlay that you're presenting that's been revised, is that the, you know, something that you're going to comply with, or is it just another view of it?
It's a concept for the board's education, or whatever.
So it could, the homes could end up in the middle between the two of them, right?
Well, we can show nothing.
No, I understand. I'm saying, let's say theoretically this is approved, when you go for building permits, the homes could end up in between where they're shown right now, right? This is not a set plan of where the homes are, it's just conceptual.
Well, what Bill is saying is to lock these locations in is.
And that's what I'm asking, is that something that you're agreeable to?
Yes.
So
Having like a setback requirement for the primary residence.
Right.
having it comply with, the concept plan that's been presented. Okay.
And if I could just speak to that very briefly, in my introduction, I commented on the proposed lot 50.01 with respect to locking in the home in that location, just because that was the lot that was brought to our attention from the neighbor. So that's why I said that that's something that we would agree to do. But if the board wants all the homes locked in this approximate location, we can do so and come up with a setback requirement.
Okay.
Just need a number, you know, how many feet.
And this setback is only with respect to the principal dwelling.
Principal structure.
Mhm.
Not pools, sheds, patios.
What if you put a heat source on the driveway that you don't have to?
That,
What if you put something on the driveway that would melt the snow instead of needing to? Yeah.
That's my dream.
Mine
Oh,
too.
every time it snows, that's like
Yes.
in my dream. Oh.
Yeah, that's
Yeah, I know
amazing.
someone who does it.
Of course, if you tell me that's not that expensive to do, I'm going to be really upset because I assume that's a very
No, it is.
expensive solution.
Well, people that are buying these homes are,
Well, I'm talking about for my limited driveway.
yes, oh, yes, same.
I have a giant track.
One of the comments on page 4 of 12 of my review, in the bulk table, is a footnote, is that the hillside development calculations did reduce basically, the allowable lot coverage. It wasn't up to the maximum in the zone because the slope calculations impacted it. Because I didn't have a chance to review those, I'd hate to go through each of the numbers, but can you just tell me if they've, as a result of the change in the slope calculations using the 1 foot interval, have the improved lot coverage and max floor area ratio increased as a result?
I gave him the mic, unfortunately, I don't have them with me.
Here they are. It's hard to read, but
Yeah,
I made a handout to give to the board, but then
it did go up because the amount of coverage or amount of steep slopes went down. I actually have it.
I can read the exact numbers if you need to.
So what you have, this is what was submitted. This is based on the 1 foot contours? Yes. 4, yes. So what we've done is we made an overlay and
So another overlay we can mark.
Exhibit 3,
A3.
steep slope overlay.
Yes.
No, there's more.
where they mostly went away was actually in the front. You can see these because there's no 10-foot contour in between. So these went away. You can see it's in this area. These are somewhat consistent. Obviously, the steep slopes are consistent. These smaller ones, so it's the smaller ones that are between the 1-footers that theoretically went away because you're supposed to measure it in 10-foot intervals. You're supposed to use the 10-foot contours.
And I,
The 10 foot, sorry, I didn't mean to say 1 foot. It appears at the rear that there's more steep slopes identified that kind of block back there.
But they're
They're a smaller range of slopes.
yes,
Okay.
they're the 10 to 20 as opposed to the 20 to the 30 and 30
Okay,
and above.
understood. Which would all impact the hillside development calculations. I would recommend to the board that if this is looked favorably upon, that Bill and I have a chance to look at those calculations. And my recommendation in my memo is essentially, if those calculations end up with them having a lower allowable FAR and lot coverage, that those numbers be locked into the resolution, just to make sure. And they're obviously going to be different than the ones I identified in the report as that recommendation, but whatever they end up being, I'd like the chance to review it with Bill and then to put that in.
Mr. Arman, I do have a supplemental exhibit that I could pass out to the board. I don't know if you want to take a look at it now, or, okay, we'll do it
No,
another
no.
time then.
It's a little too
Figured
late.
It's going to be
and-
hard to
yeah.
do this on the spot.
No, it's a little too hard to do on the fly, exactly. You're correct in that the trees that you've taken credit for at the frontages of proposed 50.02 and 51.01 can be credited towards the requirement for the street trees. But I will say that's upon inspection that those trees are suitable and in suitable condition. So would you be agreeable to a condition that if they're not suitable, that they would be supplemented with the
Well, if it's
street
not,
tree?
yeah, if it's dead, we'll take it down and put a new one on, yes.
Okay, correct. So as you've shown
Absolutely.
on 50.01, there's 2 red maples at the required interval. So you'd supplement with the required street trees at the required intervals where necessary if they're
Yes.
deemed not suitable. Okay,
Yes.
thank you. Okay, I think that's all I have for right now. Thank you.
Thank you, Ms. Sarmat. Any other comments by the board or questions? Are there any members of the public that would wish to ask questions regarding Ms. Stires' testimony? Please feel free to come forward at this time.
Good evening. I'm Dana Caparosa. I'm at 65 Twin Oaks Road. I am Block 718, Lot 64. I'm directly below. I am the steep slope. So obviously, I have great concerns. Mr. Stires, I was reading in your environmental impact statement, you had said the type of soils were hydrologic soil group C, and that organic matter content is medium to high and runoff is rapid, and the hazard of erosion is severe if the slopes have been cleared and left bare. Your stormwater management report, however, says it's hydrologic soil group B. So I'm not sure what it is and if that impacts the use of these dry wells, if it impacts your calculations and the runoff. Obviously, I have a lot at stake. I don't want to be like California mudslide territory. I am directly below. And I have well water, so I have concerns because I do have a well, and that is where we get our drinking water. So these are questions I'm hoping you can answer.
Yeah, as far as the soil classifications, they're generic. You get them from a soils map. A lot more recently, they have like a website. So again, they're mapped by county, and you can kind of get zoomed down into the towns. So they're very generic. The more important thing is the report that we actually got. So that is site specific, very specific as far as the soils themselves, whether it's high ground, whether they perk or not. So we do have that report from the actual testing. I think more importantly, as far as you're concerned, is moving the houses forward. That, like I said, that ridge line is approximately in this location right here. So everything going towards you is going to remain unchanged. Any of the runoff coming from these houses are actually going to drain towards Mountaintop.
Your report said it drains to the southerly portion of the property,
Currently.
which is
Currently.
mine. It says it was going to mainly continue to drain to the southerly portion. And I can tell you that, I'm concerned, where is it going to run off to? And I don't know if you're replacing those trees at the southerly portion there?
These are supplemental.
Those are supplemental? Okay, so you're not cutting down any existing trees?
No.
Okay. Because your original plan had 38 trees being removed, and a significant number of them were taller oak trees. I did the math. There were a significant number. It was 38 trees. A lot of them, some were 20 feet tall, some were 18 feet tall. That, just anybody knows that if you have a tree removed, a lot of the water is going to just have to go somewhere.
Well, like we testified to before as well, we would agree to a 75-foot conservation easement. So anything in this area would not be removed. So,
And I know last week you testified with the Hulu application that you don't like dry wells, but they're being proposed for this property. And I understand if those become clogged with leaves, if the homeowner doesn't care for them, where's that water going to go? Because in our neighborhood, there are leaves. You can see it on the streets with the sewer grates when the town doesn't clean them out. I can't imagine a homeowner's actually going to trudge to the backyard of their property and clean these out. So where does that water go? And how does that affect recharge and the stormwater runoff?
well, they actually don't drain. Surface water really doesn't drain into the dry wells. So the roof leaders would be piped into the dry wells, and then they would drain into the dry wells. So they don't typically have grates on them that they drain into.
Right. Well, I didn't mean to compare them like that. However, they do become clogged with leaves and debris and sediment, which is very common in our area, running through, and they might not drain out because of that. So they might be clogged if a homeowner's not caring for it. So where does that go? What's going to happen then?
Essentially, it would, again, these are going to be relocated up into this area in all the cases. So if anything, it's either going to sit in the yard, to be honest with you, or it's going to drain towards Mountaintop. Because those dry wells, there's 4 for each of the houses. So the dry wells are essentially like 8-inch or 8-foot rings. So they're still going to hold a substantial amount of water.
But if they're not cared for and maintained, then what?
No matter what you select as far as stormwater management, everything has to be maintained. And we are making an operation and maintenance manual, which is required by the DEP. It's going to be filed with the county. It's going to be part of the deed. There's nothing else we can do. We can educate the homeowners. It's the same with, like we just talked about, the homeowners, the business owners, the stakeholders in the entire state. Everybody's got to learn about it, and maybe it'll make an effect on stormwater management. We're all talking about it. All the board members, everybody in the public. We're doing what we can, and we're doing it in conformance with the regulations. So, other than that, it's hard to give you a better answer than that.
Well, like the township here, I would like to have a better solution that would work, because if I get stormwater pounding towards my house in a mudslide, hey, we put it in the operation manual and on the deed, that's not going to help me out.
Well, I said, like, as far as you're concerned, nothing is changing on the downslope side of the ridge. We are moving it forward. We are beyond, so it would have to go uphill before it got to you. And in most cases, water doesn't go uphill.
But your report said it drains to the southerly portion of the property, which is mine, which is lot
We're also
64.
moving it forward, like I said. And I believe, I'm almost positive, the report should say that the existing drains from 2/3 back to the south, drains to the south, and the rest drains to the north.
And do you guys have an arborist or somebody in terms of which trees are going to be targeted for removal to construct this?
It would just
Should there
be
be?
whatever's in the way of the development.
Should there be an arborist to do that?
I don't believe so, because if it's the middle of the house, the arborist is not going to say, there's nothing he can say, it's got to go. But at the same time, if we take a tree down, we need to replace it, and in Bridgewater, it's not 1-to-1.
Right, but I know
So
some of the trees you're proposing they're evergreens and those types, and everybody knows during Superstorm Sandy, those are the ones that were falling. Where you have an oak tree, there's, pretty steady. If it's alive,
We have a mix of evergreens and deciduous that we're supplementing with.
right, that's all, yeah, it's pretty much evergreens and spruce trees and whatnot. I didn't see anything about other trees there.
These larger ones are deciduous.
What type? I mean, oak trees, maples?
Is a variety of, unfortunately, I don't have the schedule.
I mean, something that's going to suck the water up and not be subject to falling in a 100-year storm that happens every, 5
Maples, you
years
have
now?
lindens. So there's a mix of deciduous trees.
There's nothing, is it specified? And I don't have the thing before me from the original plan. I don't have your new plans either. I pulled whatever from the website, the township's website. So will all that information be on the website, all the new information that you were referring to tonight?
These are the plans that were submitted to this point. The revised plan is just what you see before you right now.
The hillside development plan, is that what, because I think you're referring to something else that was just submitted?
It's a set of 9 sheets.
Okay, and that's on the township's website, so I can locate that?
I know that hard copies are with the township. I'm not sure. Yeah, we did give a electronic copy, yes.
Okay.
A copy and 24 hard copies were given to the township.
Was that with the original or the completed
Yes,
application?
this is a supplemental exhibit.
Right,
Okay, so this is the only supplemental is the overlay?
Correct.
Okay, so I can come to the township and get a copy of that then?
We would have to submit that. This is, right now, it's an exhibit before the board.
Just to confirm, we have not received that exhibit either.
Oh, okay. 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 And then just finally, in terms of like the impact on my well water, I just want to make sure, like, if I have all these, lawns, whatever, fertilizer, is that going to have any impact? It's going downhill, or is there just enough
Again,
hydrology and
everything from the
rocks and
ridge-
whatnot?
Everything from the ridge going towards your house is not changing.
So it should be able to sufficiently be filtered by the time it hits my well, which is at the very base of the mountain.
I would say whatever it's doing now would continue to do so.
I mean, my house has been there since 1963. We've never had an issue. I haven't been there since then, but I've been there 20 years. We've never had an issue. So I just want to make sure that continues and that we don't have any mudslides and that there's no erosion and subsidence of the steep slope, because I know that there is that concern.
And again, that's another thing that was taken into account with the stormwater management, to try and treat this individually as opposed to a larger detention basin, because, for it to run downhill, then it would impact you. You'd have a larger basin that would accommodate all of this. Rather than that, we did the dry wells, and the intent with some sort of treatment with the driveways. So it's site-specific, very condensed as much as possible.
Okay. I have to be honest, I'm not entirely confident in the proposed plan with the dry wells and the, and the maintenance of that and the pervious driveways. So that's, I have concerns about how that might impact me, but that's all I have. Thank you.
Thank you.
Good evening, Mr. Chairman, members of the board. Samantha Alfonso of Alfonso and Weber here on behalf of the neighbor, Sema Tekine, who has been referenced here tonight. Unfortunately, as the board may be aware, I did file a request for adjournment earlier this afternoon because, like the application first heard this evening, it's our feeling that this is not prepared for hearing at this point. Our understanding was that there was an agreement to be reached with the applicant. The neighbor, Sema, had met with the applicant in person at the site, all good. Some emails back and forth regarding the details of that agreement. And then, much to my surprise, I was told this afternoon, late this afternoon, that there was no agreement. And now today, for the first time, right, after 4 p.m., we're looking at a new plan that does
I'd like to
adjust
place an
the
objection on the
location.
record because the board is not privy to any private agreement between an objector and the applicant. And I'm not going to address the specifics, but we're requesting a variance. I'm not saying that just to protect my client here. There's variance relief requested. I don't want to in any way prejudice the board in their evaluation of the variance because the one objector, now there's two people not necessarily objecting, but that there's a private agreement or arrangement between two private parties. Whether the applicant agrees to accommodate an objector is really not outside of this setting here, is really not a matter for the board's purview.
It's something that was testified to by your expert.
If we were going to engage in any type of formal
Multiple
settlement
times.
agreements, I would have requested, just as I had for any other settlement agreement, that the rules of evidence 408 would apply just like it normally would for any other settlement, so that if things fall through, the board wouldn't be prejudiced by an understanding that may have been in place prior to a formal settlement agreement. So I object to this, and I think it's not appropriate for the board to hear about discussions between an objector regarding a settlement agreement outside of this hearing.
And the applicant is entitled to proceed with whatever documents and exhibits that they've filed. And at the end of the day, if the board finds that
Absolutely.
not sufficient, then the board will take that into consideration. The applicant is certainly entitled to proceed.
Absolutely. Thank you. I just wanted to note that that's why I'm here tonight, objecting to this application instead of coming to you saying, yes, we agree. Great, you've moved the homes. We're going to go through questions, if that's okay. Thank you.
I'm sorry, Mr. Chairman, I'm a little bit confused, and maybe I'm not the only one. You're representing the neighbor, I'm not, that neighbor.
Lot 49, correct.
Okay. And so we heard earlier in this testimony that there has been a friendly agreement about the location of these homes to the satisfaction of that neighbor. Are you suggesting it's not that simple?
That's my understanding now.
Okay.
I mean, if I can just address that, this plan that you're seeing came about, this is the first time I'm seeing it as well, and my client hasn't, this really, again, is not for the board's purview, but my client hasn't communicated whether there was an agreement of the minds to any of the other points raised in that letter, in Ms. Alfonso's letter dated today. As far as the location of the home on lot 50.01, I very clearly represented to the board that as a gesture of good faith, even though the applicant isn't required to do so, they agreed to locate the homes on the front of the property. It wasn't until today that I was approached by Ms. Alfonso about a written settlement agreement at around 2:30 p.m. this afternoon without any discussion with my client.
If I can interrupt, I mean, I don't know that we're going to get much further this evening anyway, given the time and the board's policies. So perhaps Mr. Stiers did indicate that you could provide paper copies of the Exhibit 2 the alternate plan? They're looking at the overlay. I'd like to see it as well and have it at the end of the day. So perhaps you could get a copy of that to Ms. Alfonso, you know, soon, so she can review with her client, and who knows what magic will happen between.
I would be happy to do so. Again, this is the first time I saw this today as well.
Understood, it's a fluid situation.
I do have a few questions for Mr. Stires, if you want me to proceed. I know it is late.
Are there any
Please,
questions? Please, yep.
Okay, thank you. One of the points that I understand the Sama and Len had spoken about is the side yard setback. What is the now proposed side yard setback to lot 49?
Just under 40 feet.
Okay, and the current building?
Just under 52 feet, I believe.
I believe that was one of the points, right, that was discussed among them, that we are asking that be considered to stay at 61 or at least increase that setback, because I believe sorry, that's not a question. What is the setback on the other side?
The other side of what?
The other side of that same lot, proposed lot 50.01, the other side yard setback proposed?
You're talking from here to here?
I believe it's a little over 44.
Yes. Correct.
Is it possible to move the home a few feet to that side to allow a little bit more buffer for the neighbor who's asking for more buffer?
What we typically do is put the driveways 10 feet from the property line and then 35 feet for the driveway. So it's kind of driven by the requirements of the town, actually.
Was putting the driveway on the other side considered?
On the other side, you'd have a driveway 10 feet from the property line. So this is probably your maximum setback distance.
The home further, right? There was a question earlier about whether or not you would do a bioretention basin, or if there was another way to comply with the stormwater standards. Could you comply if you had 2 homes instead of 3?
Wouldn't be here. And have a building permit,
So was,
type of approvals or notification to you.
thank you. Was there consideration given to improving the existing home?
Excuse me?
The existing home on lot 50 right now?
Right.
Was there consideration given to subdividing and keeping that home? And just adding 1 or 2 other homes on the existing lot 51?
In place of the existing house, and then subdividing similar to this, but the western lot would be larger, and so would the house.
Consider improving the existing home that's there?
I don't believe so. I know when I was
You
out there, it
aware?
was kind of run down.
Are you aware that a building permit was issued, approved, finals, inspected, everything, 2006?
No.
For an addition, alteration to this existing home?
No.
Are there any patios proposed now?
Everything's shown here.
Okay, and what's the proposed?
We'll get actual building plans, and if they go under contract, they would go into, if they want a pool or anything else.
What's the estimated proposed lot coverage now?
I don't have it with the moved houses. I don't have specifically.
We have that. No?
It hasn't been updated with,
Oh, it has been updated because of the new location.
well, because of
I got
also the 10-foot contours.
I got it.
Yeah, this is even before I moved this though.
But it would show your maximum allowed.
Is the driveway area included in the
Yes.
calculation for, it is, right?
That particular lot would be just over 16%, which is less than the, if it were on a flat piece of ground, it would be 18%.
The plantings proposed, those are along the rear property lines. Are those within the slope area? Is that going to cause an issue with digging?
They are not into the slope area, except in this area right here. This is, believe it or not, relatively flat.
I guess my other questions will have to wait until we see these plans, because I haven't had a chance to take a look at the landscape schedule or, those lot coverage calculations, et cetera. So I'd like to keep it open for potential further questions if possible.
Thank you. Anybody else? Okay, that'll close the public portion for this witness. Any other comments or questions for Mr. Stars? Mr. Atkins, please, quick one.
The trees that you're planting on the sloped portion, I guess the southwestern most side of each of the properties, how high are they expected to grow? Could they impact the view of neighbors?
Absolutely.
How high do you think they might grow?
Standard.
Standard?
Deciduous
But
trees.
from the level that they are planted versus the level of the houses?
Say that again?
From the level that they are planted versus the height of where the houses are positioned?
Her house or our house?
Neighboring houses.
So she's roughly at elevation 420, which 420 is really running in this location right here. So these are down below that.
And there are currently trees there?
These are,
Or?
yes.
Okay.
Yeah, I mean, there's trees that are in like window wells, I guess you could say. So they're all 30, 35 feet, and these would end up being the same. The evergreens wouldn't. They'd probably get to, 10, 12 feet, yeah. But the thought of the deciduous would be to grow to 30, 35 feet, yes.
Mr. Silbert, we have turned into a pumpkin, so
Two.
we'll need to resume this at a later date. And I'd like to ask Ms. Probst what the calendar looks like next few days.
Not on October 8th, though.
On October 8th, correct. We're all in agreement there.
I'm sorry, those are for June 4th?
I have a conflict on June 4th.
One other thing, just for notation, I don't think we're going to have a quorum problem on June 4th, but we will want clarification that with an election occurring that night in the conference room, after early voting has occurred through that Sunday in this room, I think we would just want to double check that we will in fact have access to this room on June 4th. Because early voting occurs through Sunday, June 2nd. I think they clear out pretty quick, but the conference room just behind us is used by 2 voting districts. Just so that we don't have unhappiness that night. And then as an additional note, as I guess Mr. Pappas is looking into that, there may be a quorum challenge on June 18th. Okay.
So at this time, there is no hearing scheduled for June 18th? Or
So when are we carrying this to? June? July 16th?
Can I ask, okay, I'm sorry, go ahead.
I was just going to say, for the public who's here for this hearing, this hearing's being carried to July 16, same location, same time, no further notice will be provided.
I'm sorry, not to complicate things, can we just go back to the date that we provided Mr. Silber for the other application? Because you quoted, I think, October 8th.
Yeah.
That is not the first Tuesday in October.
We have to, yeah, we'll renotice anyway. We're going to renotice.
All right, so if we are meeting on the first Tuesday of October, that would be October 1st. That's been bugging me for like 2 hours, by the way. But we've got like 6 months, we got like 5 months to figure it out, so.
Right.
Okay.
Right.
Yes. Well, they use this room for early voting through Sunday, but they use the conference room for 2 districts of voting. I mean, given that it is an anticipated light turnout primary, it probably would not be a problem, but certainly double checking it is always a good idea.
Nancy, I also just wanted to ask about October 8th. Is that an actual date we have? I thought we have October 1st on our schedule. I thought it's the 1st and the 3rd.
It shouldn't be. That was my mistake.
Yeah. No, I think it's the 1st and the 3rd, so it should be October
Yeah, it's
1st.
October 1st. We were gonna have to renotice anyway for
Okay.
it, so.
Unless you'd like to come before our zoning board.
Say that again?
Unless you'd like to come before our zoning board.
That's true. Then it'd be a new application.
That's right.
Although I don't think, there's a strong likelihood of that.
Mm-hmm.
First, yes, 1st and 15th. Okay. Notice has been given. We will carry this to July 16th. Yeah. Yes, please. Okay.
Do you have the form?
Are we supposed to fill something out?
Attach the email.
Oh,
Okay.
okay, because I
have it, I just forgot it. So if you had something, I would just.
So ultimately, when is the next meeting is, please?
can you tell us?
Next meeting is?
Oh, when the next meeting? He's wondering when the next meeting is.
Could you confirm when the next meeting date is?
June 6th? June 4th? June 4th.
June 4th? Thank you.
It's the evening of the 2 extensions, I believe. Okay.
But does that, very brief then, and you're.
And are you able to tell us who has returned the stormwater thing to you? Do you know who? Okay, I'm trying to remember if I did.
No hearings then.
I know I did it, I just don't know if I sent it.
Yeah, that's it. I signed it, I just forgot.
Okay.
Even though there's a primary election going on, given that limited scope, I don't think it should be a problem.
We can make bets, but.
Me too.
All right, drinks on you.
Yeah, drink, there you go.
Right. Can I make
Okay.
a motion to adjourn?
Did we have
No,
one
do
item?
have-
to-
We do have one other
I
item
second.
here. Okay, so we do have one discussion item. Moving on, close the application portion of the evening. Ms. Sarment, as our board planner, would you like to give us an update on the master plan? Sounds great. With that, I'll take a motion to adjourn.
I'll make that motion.
I'll second.
Laura, second. Mr. Atkins, all in favor?
Aye.
Aye.
That's it. Yeah, her with the suitcase on wheels. To get it over.
Yeah.
Tickets for